Yeah,
Yes.
two matters were running in the supplementary list of your lordship, but unfortunately it was gone down in the monthly list. Some urgencies are involved. So any day subject to correction or convenience to. I'm giving the
What is the urgency?
urgency is there in respect of the post of headmaster. Although there was an initial direction by the honorable court to take a decision in respect of their recommendation. Also, my lord, hearing done, but order has been passed directly contrary to that. I challenge this. There was a
Okay, you give the number.
My lord.
It would be updated.
my lord, get
List
any day.
for- List.
But I believe my lord is in a.
Today's
I believe I can.
today
I believe
condition
my lord
is
is in a good mood, Lord.
listটা কয় আমার
My lord, a list of them.
হ্যাঁ
But there is no resolution or no adverse order.
today
Yes,
Already
the bar has sent. Lord, it has been in our WhatsApp group. We find that the Honorable Chief Justice has
consented to that.
consented and directed Lord circulation. So there will
Oh.
be many non-appearance in your lordship's court.
oh,
Lord,
my
yes, the main non-appearance is there.
court is not there, my EL is not there today.
Your lordship's court officer has Lord not to attend. Taken a resolution of not to attend.
Has not reached us yet.
Lord, I have a request. Lord, I believe my lord is in a good mood. I am going to make a request. Lord, one matter on my prayer, my lord fixed on 11th of July.
July, yes.
Lord, I'm 11 July at 2 p.m. Lord, 11th July, Lord, I have some personal difficulty. Lord, I have given them notice. Lord, my lord may recollect that matter, Lord, the railway acquisition matter.
Yes, yes, yes.
Is that, Lord, can it be on any other day? But
If you
I don't want to
the
embarrass you.
matter to fix at 2 p.m., it will go most probably last week of July.
No, at 12 p.m., 3 p.m., any day, as per a lordship's diary, I am cannot, Lord,
এই
a beggar cannot be a
ওনার
chooser.
diary-টা
It's
কোথায়
my
গেল?
fault, Lord.
ওনার একটা
Whenever it
ডায়েরি
comes
আছে
to-
ওই ইয়েটা কোথায় গেল ওই ক্লার্কটাও আসেনি আমার না এশিওর একটা ডায়েরি আছে
Issue একটা diary আছে। Issue করে phone
ওকে
করুন।
ইউ গিভ ইউর নাম্বার let him come হ্যাঁ
Lord, after he comes back, I'll again come and renew my
yes
prayer.
yes yes
That will be better, I believe.
yes
I have given notices to all, Lord, all
Yes.
state, my other sides. I'll again
ওরা
come.
টেলিভিশন ওটা আপনি ওটা হ্যাঁ বুঝতে পেরেছেন 11ই জুলাইয়ের বদলে ওটা অন্য একটা কোনো ডেটে দিয়ে দিতে হবে হ্যাঁ কিন্তু ডায়েরিটা লেখা আছে আচ্ছা ঠিক আছে ওনারটা you give the slip yes you have 3%.
I'm extremely grateful.
Magistrate matter will appear as to be mentioned.
Yes.
It appear in the monthly list, item number 131 and 132. Let it appear tomorrow as to be mentioned.
131
131 and 132.
it would be taken up in this week
My lord, after completion of supplementary list, my lord, tomorrow my lord, as to be mentioned, covered by lords.
no today it has been given but
Other side.
okay you give the slip হ্যাঁ তাই দেখে কি হবে
Item number 1 and for the
same matter 3%
correction, my lord.
correction oh
My lord, I have corrected, my lord. Paragraph 3. My lord, date of the appointment and name of the.
paragraph 3
My lord, I have corrected it.
31st
My lord, it will be third.
oh and the school
Name of the school, my lord.
oh Banga it would be
Yes, my lord.
Bagdanga oh
And my lord, another, my lord, the paragraph 5, my lord, my lord, the amount 9,910.
oh it would be 26,000 okay okay let them come they will do it yes এইটা এই অনুযায়ী হবে এখানে এক্ষুনি কারেকশনের জন্য এক্ষুনি হয়ে গেল এটা অর্ডার বুঝতে পেরেছো ওরা থাকলে আমি এক্ষুনি ডিকটেশন দিয়ে দিতাম বা এইটা
ওইটাই
ওরা করে দিতে পারে। সুমন বাবুকে দিন করে দেবে। Yes, next. Next also some mistake.
Another line has been, I have corrected, but subsequently he appointed as an assistant.
It is required.
Not required, my lord.
Yes.
Only my lord, date of
So,
name of the spelling of the name of the school. Gunananda. One of the spelling is the one of the high matter instead of
okay. এটা পরেরটা দিন, পরের ম্যাটারটা 2 নাম্বার 2 এর ফাইলটা দিন। হ্যাঁ, ওটার মধ্যে এটা রেখে দিন। ওটার মধ্যে এটা রেখে দিন। এখানে কারেকশন হবে, ব্যাপারটা বুঝতে টাইপোগ্রাফিক্যাল মিস্টেক হয়েছে। দিন ওই অর্ডারটা দিন, যেটা আমি হাতে দিলাম, বাঁ হাতেরটা। হ্যাঁ হ্যাঁ, এইটা এর সঙ্গে হবে। হ্যাঁ, এই নিন। এইটা এর সঙ্গে আর ওইটা ওর সঙ্গে হবে। নিন।
তুমি যাও।
যাবো। এটা কি আছে জানো? মিস্টার লাইরি। ও
ইয়েস,
well, kindly
রাখুন। হ্যাঁ,
recollect that matter, mobile tower. Yesterday, wrong file was
Oh.
to your lordship.
Item
Your lordship,
20.
Item 20, my lord, that order has
item 20, yes.
Yesterday just.
Yes.
lordship recollect that.
দিন তো পরেরটা।
And my lord, direct to the officer to put that order in this file. Yesterday's order, item number 20. I don't know whether that order is there or not.
No, that order has not been finalized. It's like item number 20 of the list dated 7/7/2025.
Yes, ma'am.
Disposed of.
Same order.
Well, here, my lord, respondent, private respondent is my lord. Here,
আর কি আছে?
না ওতে রেসপন্ডেন্ট গুলো বলা আছে তো, ওগুলো তো কারেকশন করতে হবে। মানে প্রাইভেট রেসপন্ডেন্ট 12।
With necessary changes.
Yes.
With necessary changes, yes.
Only the, my lord, number of the writ petition, cost title, and my lord,
And yes,
nothing more.
number of the private respondents, yes.
Fifth one.
Yes.
Item number 4.
এই আপনি পারেন না সঠান? আপনি পারেন না? ও আচ্ছা, কেউ আসেনি এখনো? আবার খোঁজ নেবেন নাকি? আবার খোঁজ নেবেন ফোনে?
এই দু সাইডই লেখা।
ফোন নাম্বার নেই? ওকে, শুনি। দিন পরেরটা দিন, 4 নম্বরটা দিন।
My lord, in item number 3, my lord, I am for the respondent number 12, private respondent number 12, my lord.
You give your name. Yesterday, one matter, after hearing, one matter has been disposed of by remitting the matter to the grievance committee. Pursuant to the direction of a division bench of this court, one grievance committee has been constituted by the state. And the direction was given that the similar issue shall be referred before the grievance committee. And accordingly, the matter is being sent to grievance committee for consideration.
My matter has been disposed of, item
A
3.
matter has been disposed of. Similar matter has been disposed of yesterday.
Four. My lord, I am appearing for the petition.
Lordship, I appear for the respondent number 3 and 4 in this matter. Lordship, I'm praying for filing my affidavit in opposition in this matter. Not served. File could
Four is a
consideration.
the direction. Well, only it is the matter about the consideration. I have paid for the authority. For regularization of the allotment regularization of the
Quarter.
Quarter. In terms of the scheme. Scheme started at the page of 52. Representation page 45, my lord. Kindly see.
Ex-employee contract labor. You are a contract labor of MMC, Durgapur.
That is the provision in the scheme that I have annexed 52 page. Kindly see.
You are contract labor.
Yes. Eligible. In terms of the scheme. And I'll also kindly see the page 57.
আসুন বুঝতেছি
Lordship, I have taken a point in this matter, Lordship. That is why I have paid for filing the opposition. Lordship, when on the date of final
Let me finish and lordship.
on the date of final settlement,
You are appearing for 5 and 6.
3 and 4 ADDA.
For respondent number 3 and 4.
Yes, sir.
That's very.
Lordship, kindly allow 2 weeks.
Have you served upon the respondent number 5 and 6?
Yes.
They are the answering of no. MAMC 5. Respondent number 5. Where is the affidavit of service?
Notice of
Notice of mention.
No. Where is affidavit of service? Affidavit of service, you have to show you have served the copy of the writ petition upon the respondent number 5. Respondent number 5 is the main answering respondent.
Yes, sir.
File, mother,
Affidavit of service is filed.
in the file.
So I am keeping it.
My lord,
I am fixing this matter on any other date. You serve a notice intimating that the matter shall be taken up on that date. Where is affidavit service? Not affirm. Not affirm. This is the record. No affidavit service. So you have to show that you have served. Otherwise, direction for mention notice of mention would not
and the Xerox copy.
suffice. You have to show
That is the Xerox copy I have to show. That is
where is the original.
there, advocate, file this affidavit of service. In the file, it is supposed to be in the file.
So check the file.
Then my lord pass the order.
This is the first time
Yes.
action is taken up today.
আচ্ছা আসুন ইন্দাস বাবু আচ্ছা during the course of hearing, the petitioner unable to produce the certified
The Samapoto Sharma was the owner. Petitioner is the owner of Gratuity and the matter Samapoto Sharma was the owner of Radharani. But I virtue of a registered deed minor, I purchased the business of Radharani person. Subsequently, my lord, the license has been renewed, but the name of the owner has not been changed. Although I have purchased by virtue of a registered deed, and my lord, I filed a suit. My lord, suit for declaration that I am entitled to keep the name in my name. That decree I have annexed, my lord. First, my lord, Chapter 7. One of the page 18. Annual report with the of Radharani
Timberwork, yes.
Next page, my lord, 90. আপনার নামে রাধারানী আপনি বলে আমার পরিবর্তে আপনি রাধারানী যাবতীয় মেশিন যন্ত্রপাতি সমূহ উঠাইয়া লাইসেন্স আপনার নিজের নামে লাইসেন্স পত্র করাইয়া Therefore, I have purchased the business, instrument, machineries, not the land.
Purchase the land from the
I have already the land. I am carrying on a business in a different way. All those machineries to my, and I am carrying on both the business. And another thing, with application for renewal, page 22. It is of the year 2001, but the safety was of
but renewal was granted in name of erstwhile owner. Erstwhile owner.
Name is required to be changed. See the forward snapshot. Petitioner's name should be there. This is my prayer.
Yes, Mr. Sen.
Let him place the other title suit judge.
There is a suit, and suit was dismissed, subsequently come to page 34. The first appellate court degreed the suit and passed a degree of declaration that the plaintiff is entitled to license in his name in respect of Radharani timber works and dependent number such and such has no right, authority to deny, renew or grant license in the name of the plaintiff. The state of West Bengal and divisional forest officer was party to these proceedings. So the order is binding upon you. The order is binding upon you. You cannot deny.
The name of the defendants,
Page 25.
page 25.
Divisional forest officer and state of West Bengal.
That is true.
No appeal has been preferred.
But in my written instruction, only thing that it appears that whatever stands were taken by the forest department, almost those are the, my lord, the stand till today as per my instruction. But since there is a degree and my lord, these points were taken into consideration therein, now my lord, just I
Lord, kindly grant me at least 1 week time. Let me have a discussion with regard to this. That what is the whether there is any further any further.
So what will be the utility or use of keeping the writ petition pending? You act in terms of the degree of the appeal court. You are bound, you have not preferred any second appeal. And the order was passed when Mr.
Question is, my lord,
Mahato, order was passed in 2020. 5 years already left. Yes. The present writ petition has been preferred, praying for a writ of mandamus
is also the owner of the, I think he has purchased the Radharani. So license can be renewed in his name. Now the question is, Lordship, kindly consider that the suit court dismiss the suit, but the appeal court, while set aside or my lord the
set aside the
or restored the suit,
dismissal order of dismissal of
order,
suit and ultimately
and
decreed
the
the suit.
appeal court said that yes, in the name of Radharani, the license be issued in favor of the petitioner or plaintiff. Now the question is that in the guise of the name of Radharani, whether my lord Lakshminarayan Sawmill can also have the permit or entitled to the license without following all procedures, only because, my lord, that the transfer of the Radharani property, that cannot be, and the degree also, my lord, it is silent. Degree, my lord, I have gone through the degree, it never said. So, in the name of Radharani, when it is a degree dangling over me, so very good, I cannot deny the degree having not been challenged till date, or to me there is no such instruction. So very good. As per the degree, license can be issued in the name of Radharani only in respect of property purchased from Radharani, but not Lakshminarayan. Because, my lord, kindly consider my written notes, why I say so. Kindly go through this. Because today, no affidavit has been filed.
Yes.
Kindly go through. Here it is stated that
Paragraph.
that transfer may be effected with regard to the assets are concerned. First of all, let's kindly come to paragraph number 3. There are no data available in this office regarding the said Lakshminarayan Sawmill. Therefore, it is clear that the said sawmill did not obtain license from Forest Department to establish and operate. No Gram Panchayat has authority to legalize a sawmill by issuing a license. As far as legalization of a sawmill is concerned, Forest Department is the only authority which can authorize the sawmill by issuing license as per Rule 3.2 of the West Bengal Forest Establishment and Regulation of Sawmill and Other Wood-Based Industries Rules 1982. Then admission in paragraph 2 that yes, Radharani was obtained sawmill which was owned or the proprietor was Shamaprasad Sadra. Then paragraph number 5, Lordship kindly 5. As per Rule 6.3b of West Bengal Forest Rules 1982, sawmill license granted under this rule shall not be transferable and shifting cannot be done as per procedure mentioned in Rule 6a. May I pause here? That means Radharani, which was operated from site A. Now you cannot see that having been purchased site A, so I amalgamated A and B, and so Radharani also deemed to operate his business from site B. You cannot. There may be a degree in favor of him, allowing that, very good, license be issued in the name of Radharani to you. But Radharani, where firm operates, that should be mentioned in the license. That not the Lakshminarayan. Now, it is not transferable. Shifting cannot be done as per without the procedure followed therein. Then, Lordship, kindly come to 6. As per Rule 4.1 of the West Bengal Forest Establishment and Regulation of Sawmill Rule 82, every person intending to carry on business or occupation covered by these rules shall apply to the authorized officer in form number 2 for a license. In the instant case, petitioner did not submit form 2, which is the foremost criteria. He may obtain the degree. I cannot deny, or I cannot take exception to the degree here and now. This is not the procedure. But I can say that the degree which he obtained, to what extent that can benefit him. Whatever the degree says, that can benefit him only to that extent. We cannot, my lord, enlarge the scope of.
Okay, you act according to the degree. Now you are not.
No,
you will not be permitted
if
to.
the order passed in writ petition, that will not match the degree obtained by him. The language, the motto, the object, total different. Let's kindly consider one thing.
Here, Lokhinarayan never, my lord, sought for license. Lokhinarayan was not even a picture with regard to the license sawmill owner. Lokhinarayan, at a certain point of time, purchased the, my lord, the Radharani. So Radharani was the, my lord, the license holder or licensee. Now, he, after having purchased, accordingly, my lord, he said renewal of Radharani in my name. Now, objection to that, suit file, suit dismissed, but degree in his favor. Now, what the degree said, that the license of Radharani that was already therein, that means license be renewed. Let's kindly consider, license be issued and license be renewed. Well, the two connotations are different. Renewed means whatever in the original, that should be renewed. Nothing to be inserted in the license, that yes, because if I renew the license, then on the license, there should be mentioned that the place of business. The place of business, what was in the original in Radharani, that should be here. So kindly consider.
Okay, okay, I have got your point. Got your point. You
But
listen
not
to the.
Lokhinarayan. Lokhinarayan cannot have any advantage on the basis of this degree because I purchased by way of deed of purchase. Because Lokhinarayan has to apply before the authority concerned.
Yes.
There cannot be any merger in this way.
Lokhinarayan has not purchased.
Okay, আসুন আসুন কি বললাম listen to other both of you আজ কি বললাম
behalf of the petitioner.
Yes.
This is my affidavit of service.
Where is your other side?
They are not appearing.
I am told today you have adopted a
Resolution.
resolution.
Then it
So
will be not today, not today.
Not today. Hmm. Well, both sides.
Lordship, I am for IUCL, but I am today, I am praying for time, Your Lordship. My counsel is not over here. He's on legs on some other court. I'm praying for time for today.
That way, instead of you are coming since yesterday, to do this matter.
Yesterday we
But
were
you are
present.
not good,
Yesterday we were present, Your Lordship.
Do it.
No. But
At the time of call.
we
At the time of call, you are present.
were present, Your Lordship. I don't like
That even Lordship kindly take it up on
Thursday or Your Lordship on Monday. I think that if that can
ওপরে দেবেন অমল কুমার সেন, ওপরে দেবেন অমল সেন, তলায় সেন দিন। হ্যাঁ, অমল বাবু। হ্যাঁ।
Your Lordship can
That event, your Lordship kindly take it up on Thursday. But tomorrow you are in difficulty. Okay, Thursday means
Lordship,
Thursday করে দেবেন তো so
Lordship, if your
10th July,
Lordship, if your diary permits, if you can kindly fix it up on Monday, Your Lordship. Otherwise, as you wish. I'm leaving it to Your Lordship.
Objection if my learned friends has any objection. Difficulty. Tuesday, you can Tuesday, my lord. 15th?
15th.
15th? Yes. Hey, 15th, I am fairly on the top. I am top দিকে, fairly at the top দিয়ে দেবেন। একদম, হ্যাঁ, yes. Rebel returnable motion.
The order will be passed, Your Lordship, or
Oh, you are taking time again. You will be on that date. Take time. Your yet will. Yes.
I'm for the petitioner.
What can be done? You have adopted a resolution not today. Come tomorrow.
Instead of tomorrow, can it be on Thursday? That fairly at the top.
So tomorrow, what court will do?
Thursday, man.
Okay, Thursday করে দিন এটা। আজকে হচ্ছে 8 তারিখ না? 10th, yes. Item number 9.
I am appearing on behalf of the state respondent.
I'm for the private.
Petitioner is not there, not today. আজকে তো উঠে চলে যেতে হবে এখানে। তন্ময় বাবু, উঠে চলে যেতে হবে শেষে। সকালবেলা মেনশন করে বললো ডিস্ট্রিবিউটির জন্য কি ইয়েস 10 not today.
Number 11.
And for the state.
I have instructions to appear on behalf of Kolani municipality.
I think item
Yesterday, notice has been served. Therefore, my lord, I am paying at least 1 week time to take proper instructions from him.
My lord, I am appearing for the petitioner in this matter.
My lord,
And for the state.
we appear for the Nodia Jela Porishad, my lord. It is appearing at our instance, my lord. We have mentioned the matter for taking
Item number 11.
item 11.
One application is there. What is the
At
application?
my instance, my lord. That is
What is the application?
for the calling of an order, my lord, whereby Nodia Jela Porishad was, my lord,
Oh,
that
that matter you are mentioning, or Mr. Sarkar was mentioned.
it was on the other side. my lord.
Mr.
Oh.
Oh, Mr. Sarkar want to get the writ petition, entire writ petition disposed of, and you want the application will be taken up first.
Since I'm led by Mr. Sane, my lord, I'm paying for a very short passover.
Short Passover didn't, he is taking not this week. He is saying only yesterday he got the instruction to appear on behalf of Kolani municipality.
Notice দিয়েছে।
So not this week.
My lord.
I am not this week. You take instruction in the meantime.
Grateful, man.
Hmm.
If Lordship may kindly direct the Jila Parishad to serve a copy of the application. We have not received any copy of the application.
You are for the petitioner.
My lord, I am for the applicant. My lord, I am respondent number 2 in the writ petition. I am for the Jela Porishad.
তাহলে একটা অর্ডার করে দিন মিস্টার পানামল ইনসিস্ট, she is insisting.
Let me see what the facts of the reputation. It's a very simple matter.
But your learned friend says that yesterday he has got the instruction, received instruction to appear on behalf of Kollani municipality. He says, I have no instruction, so 1 week time is required. So none of the party was being able to agree to a date prior to 17. So I am fixing it on 17. Till 18th. 18th, okay, 18th. 18th, it would be placed fairly at the top. Fairly at the top. Come on that date. Get prepared and come on that date. Yes.
But even then, I would submit the municipality wouldn't have much to say here because my claim is really against the respondent number 2, which is the Jilla Parishad. Because this made the state in just
Yes.
my petitioner was approached lighting of the Kollani Stadium in public interest for public benefit for a certain agreed sum. My contract is with the Jilla Parishad. I carried out the work. Only a part payment was made, but 1.25 crore was not paid. I wrote letters to the Jilla Parishad. The Jilla Parishad has given me one letter after another admitting the claim, which are all annexed to the writ petition, saying that please give us a little time, we will make payment. Now, after a point of time, they kept and all these admissions are in writing, so there is no disputed question of that. After a point of time, they start refusing. They say, do whatever you want, we will not be able to pay. So that is when Lordship we find the writ petition. Several services were made to the respondent number 2. They refused to appear in fact, but the learned advocate for the state was present. So when it was moved before the learned legal judge, an interim payment was directed to be made because the claim is admitted. There is no dispute. Now, after that order has been passed, now a modification application has been filed for the respondent number 2, saying that the liability to pay is on the municipality. But as far as Lordship I am concerned, the petitioner, my privity of contract is entirely with the Jilla Parishad.
With the Jilla Parishad? Jilla Parishad issued the work order.
Everything and the admission of the claim, their letters are also from Jilla Parishad saying we admit our liability to pay. We are trying to make payment as soon as possible. Now, soon as possible, by saying soon as possible, several years have passed.
In this way, the Jilla Parishad is one of the parastatal of the state. You, Mr. Pajamulli, in one matter, I have also imposed a liability upon the state also. State cannot deny because your own citizens are enjoying the same. And Jilla Parishad is nothing but a parastatal. It's indirectly acting on behalf of the state.
Yes, but
Okay,
according to my
municipality, Jilla Parishad, all are parastatal of the state, indirectly acting on behalf of the state. And in this way, this body will lose its credibility. We lose its credibility. None will come. None will respond to their advertisement.
understand, Lordship, but whatever
You have taken their service. You have taken the goods from the person, or you will not pay.
Lordship,
As
How?
far as, my lord, as far as the aspect on the point of admission is concerned, my lord, I deserve an opportunity of hearing. My lord, on that particular day, my lord, I was not
You
here.
are buying time.
My lord, on the very first day, my lord, an order
You are
was passed
buying
against
time.
me.
You are
I
buying
will
time.
address your lordship, my lord. We are not shying away. You only say the liability is admitted on the part of my lord. The entire thing was taken up on behalf of Kollani municipality. My lord, Nodia was, Jilla Parishad was acting as an executing agency.
So who asked?
They have admitted.
Mr. Council, who asked you to issue work order?
My lord, Nodia, Kollani municipality. It is at
Jilla
instance.
Parishad did not issue any work order.
This work does not relate to Kollani, Nodia Jilla Parishad.
Forget about with the Nodia Jilla Parishad or such and such. Whether work order issued by the Jilla Parishad or not.
Lordship, may I kindly indicate only one thing.
Yes.
Work order was issued.
Yes.
Work was completed. The money they are claiming for is the additional work which was done.
No.
According to my instruction, it is the additional work.
My lord, there was an original scope of work. My lord, I'll address your lordship on this.
additional work, look, when any work or such sort of contact is entered into by and between the party, two sorts of disputes are come in the entire world, that he has not completed the work within the time specified in the contract, in the agreement, and he will say that when I was doing this work, some additional work was assigned to me. I have done it. This is the letter, such and such. And the payment has not been made. From the part who assigned the work, he will say that the work has not been completed within the time assigned. This problem is going on. And the contractor or the person concerned who was employed or to work assigned to do the work, he will come. Some additional work was assigned. I have done it from my own pocket, but money is not being paid. Same thing, every contact. So if additional work, no work can be given, nothing can be foretold what would be the situation. So to do one work, some additional work is required to be done. So if the contractor executes such additional work, what payment will not be made?
The letter of the Noida Jilla Parishad saying, in reference to your above noted subject, we acknowledge your demand for installation of floodlight at Kollani Stadium. You are hereby assured that Noida Jilla Parishad will honor the contract of agreement and will be making all the effort to make payment as soon as possible.
So
what remains after this?
Thereafter, no dispute. Actually, there is no lease, no dispute, nothing to be determined.
Since a question has been fallen from your lordship, at whose instance the work was taken up? I've enclosed the document in my application.
Council, come. I am not passing any order. Here and now I am inclined to. A thinking is passing in the mind of the court to direct you to come with the statement of your asset and liability.
I'll address your lordship.
And the bank statement also. If you don't say, the court has power to direct, they attach it. Okay, I am not. Yes, Mr. Sen, most probably I have got. You are leading this year and you are representing the Jilla Parishad. Yes. Jilla Parishad executed the work. Jilla Parishad has admitted and has undertook the liability to pay the amount or to clear all the dues. And the person concerned has executed the work.
No, we are not absolutely disputing that. It is now a question between the municipality and the Jilla Parishad. I am not saying that petitioner is not entitled to receive payment.
So who will?
Yes, the question is only who will. But I am saying that Kollani municipality is before your lordship. They are also a government body, statutory authority. I have done the work at their instance. Kindly see the document. They can't.
Okay. Now, since you issued the work order, since you admitted your liability to pay or clear all the dues by giving a letter to the petitioner, you pay. The court will record that if you can prove that that amount was required to be paid by the municipality, liberty will be given to you to realize the same from the municipality.
That is what I am asking now.
So I am passing that order.
No, I am showing the document.
I have made instructions at this moment.
No,
I shall file my lord affidavit.
No. Why? I have not invited you to affidavit.
Lord, I am praying before your lordship. Otherwise,
I do not find anything to be determined.
Well, kindly have a look.
Court is acting on the basis of the admitted fact.
Yes.
Now the only dispute remains who will pay the amount.
Yes.
It is going on.
But that
blame
is
gaming.
Be decided by your lordship.
In this blame gaming or what I say, shifting of liability, this tug of war, don't bring this person in between. Okay.
Well, kindly.
Either you or you decide.
Yes.
You relieve this person.
For that, my lord, I claim your time.
But may I say this? I give your lordship a suggestion.
Proper instructions, my lord.
Both are government bodies. My lord, municipality, Department of Municipal Affairs, my lord, Jilla Parishad under Panchayat and Rural Development. So, my lord, the district magistrate is the ex officio chairman of the Jala Parishad. Let, my lord, the district magistrate or at the secretary level, let a decision be taken on the basis of this document.
Now,
Okay, your suggestion is welcome in respect of the second issue, not in respect of the
The
first.
first issue has to be decided along
First,
with this issue.
no, first you pay the amount,
I
you
do not-
clear,
but-
you clear all the dues to the
No,
petitioner.
then your lordship
Let
will
the
hear me on this.
petitioner go. Don't be a victim of this tug of war, which is going on in between you and the
No,
municipality.
now,
Now, if you can prove,
I have.
you can prove that the municipality is liable to
I'll
pay,
show your lordship two
Now-
documents only.
that issue will be determined by the DM.
Well, that before that, well, kindly do not release payment. Well, it has to be closed down. We have already paid 3 crores. It is not my liability. How will I function, my lord? I am a government body,
You pay,
and one municipality is running away.
you pay, thereafter you realize from the.
It is not, my lord. They are getting the revenue from the stadium. They will have to take responsibility. And in fact, my lord,
But
I have-
Mr. Sen, I cannot allow any body of our state to violate his own undertaking, to violate his own, what I say, undertaking, and what he has, the what.
my lord, that is what I want to show your lordship. Kindly have a look at one or two documents only in this petition.
Today, my lord, let it be taken up on 18th.
Let them take instruction. I've served them.
On 18th, my lord.
Yes, kindly keep it on.
The matter was filed in 2022. You are sleeping for 3 years. Now when the court has applied his mind, then you are calm that I am newly engaged advocate. Yesterday I have got instruction to appear in this
And my lord,
matter.
kindly see,
So give
at
me
the
time.
time of hearing, only the state appeared.
When the Jala Parishad is trying to shift the liability upon your
I am
shoulder.
not shifting it. They have themselves said that it is their liability. I just want to show your lordship one page on this,
From the writ petition.
from the application. Kindly see page 19 of the application once.
Oh, so Mr. Sarkar, it would be better come on 18th.
May I have 18th, my lord? May I have only one request in that respect, lordship? That is, my clients, this is basically the Phillips group. Now, lordship, what has happened is all these people, they go outside the state because this is the situation. We all want them to remain in the state. They've been waiting for a long time. If lordship kindly makes an observation to that effect on what has been submitted on behalf of the parties about the admission of the claim, because that can't be disputed, because Mr. Sen also very fairly submits that it does not dispute. It's only a dispute according to Mr.
That
Sen
is what
about
I'm saying, my lord.
who is to pay.
Before you're entering the court, I have made this comment, although it is not, that in this way the body or state of the state of West Bengal will lose its credibility.
But that will hurt us.
None will respond to any advertisement or a tender notice henceforth if this is going on.
If an observation to that effect be made, lordship,
And the government office, all the government has no machinery to execute all the work without help of the contractor, without floating tender.
May I say
Government is not in a position. So tomorrow government is to float tender. Government is to get some work done by the person contractor. But if they don't honor the terms and condition of the contract or work order, then the state and body will lose its credibility.
But lordship will kindly say this and direct the DM to resolve this issue before 18th.
Lordship,
But
Lordship,
don't
Lordship, here I oppose
No,
because
before 18th. Kindly, your lordship is keeping the matter on 18th. Before 18th, your lordship will say the DM will sit with the municipality and the Jila
Lordship,
Parishad
here
and
this
take
is
resolve the dispute and come back to your lordship. with
here,
a report.
Lordship, I oppose because according to my submissions, whatever instruction I have got, this is the excess work which has been given or done by the Jila Parishad.
Absolutely
The
not.
government
My learned
paid
friend is not
no
aware of the
approval.
document.
I have
He is
got,
not
I have
aware of
got
the
the
document. I'm sorry
instruction.
to say.
There has been no approval by the administration.
The same sound. It is
Yes.
like
even
Same
lordship,
thing.
lordship, I can show
Same
the
thing.
lordship, I can show. This is the contract, the term.
Mr. Pajamoli, in one matter, I got occasion to deal with. Same thing that now Jila Parishad, municipality, panchayat is doing such work, the floating tender, inviting application from the intended bidder.
That approval.
Subsequently, Mr. Paja, from the Secretariat of the Department of Municipality or Panchayat, they are coming, no approval was taken.
No, lordship, that approval was taken.
Court is here
An
to tear the
additional
bill.
approval was
Well,
not taken.
I have already started saying this, that they are parastatal, they are acting indirectly on behalf of the state. And the beneficiary of this work is the citizen of the state. That is your citizen.
Lordship, I admit.
They are
but
your people.
The state has an
lordship,
obligation to.
You are not being able to
lordship,
do
if I
work.
have the obligation, then I have to make the order also, na? I
Kindly
can
have a
take
look
the
at this
obligation
page, only
only
one
and
second.
pass
Two
an order.
lines.
I can take an
Just
obligation
kindly
of
two
that.
lines. I will not say anything. Kindly see these two lines. Kalyani municipality is.
So whether you will make an effort, your DM will make an
Yes.
effort to resolve the issue.
Yes, kindly,
Lordship,
kindly
then I have
direct
to
that.
come back with the instruction because according to
everything.
my instruction, there has been no direction for the extra work which was done. The claim which has been made is in regard to the extra work. There has been no
Municipality has given
approval
that.
of such extra work.
But kindly see
So
municipality
then I have to
better.
come back because they have to take approval from the department. Then only they can claim for that. If I do not have the authority to issue an extra work,
So
then why
that
should
is-
I take the liability also?
You
They
are
have
not
done-
supposed to take the liability.
They are not, we want you to take the liability. Now they are saying, he is saying municipality will pay, municipality is saying Jila Parishad will pay.
Lordship,
You
I
are
consider
to,
only one
Mr. Pajamoli, your DM is to act as an independent
Exactly.
arbiter and to make an effort to resolve the dispute. As per the suggestion given by Mr. Sen.
That is nothing.
Lordship,
It has
only
to be
one thing
resolved.
considers.
Whether your
Whoever
DM
is
will do or not, whether court will pass another,
But
whether,
The lordship
And-
passes the order. but it needs-
Mr. Sarkar, do you want intervention of the DM?
Lordship, may I clarify two aspects?
If they settle,
Lordship,
that will
then
lessen the burden of the court.
No,
Go.
not only that, he is interested in the payment. If
Yes.
he resolves the matter, whoever will,
Be-
the
My lord,
amount
may
he will give it to
May
him.
I have just only two submissions, Lordship, very fair submissions on either side, Lordship. First is, this is no excess amount. The approved contractual amount
Yes.
was 5 crore 43. Out of that, they have paid 3 crore 70. 1 crore 65 of the contractually agreed amount is payable. The submission as to excess work, additional work is incorrect as it appears from their own document.
I am not
So,
saying any of
page
this. It
47,
is extra. or
That is incorrect what my learned friend is submitting because if
Lordship,
there
I
is
may
there,
hand
well,
over
this
one
is a
document.
statement
I
from
may
someone-
then because
But
my
I'm showing the
instruction
contract.
specifically says
Because the
that.
contract says that the contract value is 5 crore 43. Their own document says that 1 crore 65 is outstanding from the approved contractual amount. There is no
Oh, okay. So,
lordship is
Just
we
one
are-
page, your lordship will see, page 20. This dispute will, your lordship itself will
Now,
kindly
lordship, as
understand.
the second part, lordship.
Kalyani municipality, how can they go away with this? What remains after this, Lord? They are asking me to.
so I am relegating the matter to the DM.
Kindly do not.
I am not disposing of the
Yes,
petition.
Keep it,
My
my lord.
only concern is lordship.
Your concern is payment.
Yes, that
exactly.
is my only.
Yes.
I want.
You are not concerned now. Let the DM with the functionary of the state, and he also good connection with both the Jila Parishad and municipality. So let them resolve the issue.
Only, but
That who will pay?
Who will pay?
Now, lordship, the thing is that there is an order of 8 February 2012 which directed an interim payment to be made. Now, that order would have to be complied with. My only prayer would be lordship kindly
Interim payment would be made by.
by the respondent number 2 because my lordship will kindly.
You
see
have
that-
initiated a contempt proceedings.
Well, that contempt is, but if lordship disposes of the main matter, I
No.
get my money. Well, I am happy. I am only concerned with the money. My only prayer, lordship, is having waited for so long. And as far
So
as
you
my-
pay the interim payment.
Your lordship is keeping it on 18th. Entire thing will be resolved.
Lordship then
I
kindly
have
keeps it on
paid.
18th,
Yes,
lordship
I am
passes
not
the order.
saying.
My lord, that would be my prayer, because
Whether in the meantime, DM would be directed to
Yes,
intervene
that is
in the
my prayer.
matter to
Your lordship,
my lord,
then
perhaps
let
that
them
would be
come up with the
complicated.
instruction, because whatever came, the municipality has to say. Without the instructions, lordship, how can the DM also take the call, lordship?
But why is
They have to
taking
come
the
with the
side?
instruction.
Lordship can refer the matter before the district lordship for resolve the dispute.
Yes.
There is no.
Both of us are
My
agreed.
lord, I cannot be. My lord,
But
may I make one submission? My privity of contract is with the
with
Jila.
the Jila Parishad.
I don't know anyone. This dispute being talked about, this is the internal dispute within the state.
Of course, but
My
this
only submission is, lordship, why should I be relegated to a different authority?
Yes, yes,
Why
yes.
should I be relegated to a
But he is not.
money? Let the state authorities, because the municipality is submitting one thing, the state is submitting another thing, and the Jila Parishad is submitting another thing. So, my lord, they can sort out the differences. Money can pass hands, whoever is liable. But my contract is with the Jila Parishad. The law is very clear. The Jila Parishad has signed the contract with me. Jila Parishad has admitted its outstanding dues. There is no additional work. This is the contractually agreed amount. Let them pay me the amount in the meantime.
You say your municipality took this liability.
yes.
Your municipality took this liability.
My lord, I have to direct the payment.
Regarding installation of floodlight at Kolani Stadium. Municipality took the liability that I shall pay.
So that is what my submission is, my lord. Let us not go into the legal. I am trying to assist my lord.
Okay, come on 18th.
Yes.
Let's see. Come on 18th. You take instruction that you, by giving a letter to the Jila Parishad, undertook liability to pay the cost of installation of floodlight in Kolani Stadium. Thereafter, you also undertook certain liability to pay the amount. You have undertook that liability. So you honor what you have undertaking, you pay that amount, and Jila Parishad, you also pay the amount. Thereafter, don't worry, the court will take care of the fact that court will give you liberty to realize the amount from the municipality. But if relieve this petitioner who has executed the work.
We will, my lord, but only thing is, since your lordship is keeping the matter on 18th, let the DM take a decision within 18th and show it to your lordship. What is their stand?
Complicate the matter.
No, it will not. Petitioner will not go there.
Okay. Okay, the petitioner does not want to surrender the jurisdiction to DM. Surrender to jurisdiction.
Your lordship is probably, I can't express myself. I am not saying that it will be like an arbitration between three of us. I am saying petitioner is not required to go anywhere. It is the DM who will resolve who amongst Kolani municipality and Nodia Jila Parishad is supposed to pay for this contract on the basis of the documents which are there, and shall file a report before your lordship.
So there is no dispute that the petitioner is entitled to get the contractually agreed amount from the Jila Parishad.
No, I cannot say from the Jila Parishad. That admission I will not say. Under the contract, there are a lot of contracts, my lord, where, my lord, payments are conditional on the basis of principle and my lord,
the present admitted.
Yes, I do not accept admission. Will we kindly see in a contractual matter, if I say that I will be making all effort to make payment as soon as possible, that means I have made an admission regarding the quantum of work, regarding the satisfactory nature of work, everything. If I give you, if I say that I will be making payment, whatever is admissible, I will pay. It does not mean that I have admitted 5 crores is due and your work is.
Okay, admitted কথাটা আপনি কেটে দিন, contractual agreed amount.
Lordship kindly records, I have given the amounts, exact amount, Lordship kindly records the
This
amount.
is not a food court to determine this amount.
This is an admitted claim, which is why
Very
no
good.
suit is required.
Okay, on that date, court will see. Now let this blame game is over. Now let the blame game is over. In between the municipality and Jela Parishad, then what will be the amount? If expert is required to be appointed, court will appoint. Don't worry. Don't worry. You will pay the cost of chartered accountant. Chartered accountant will
Lordship will only fix any time, Lordship. Can we finish?
If you want to do 2 PM, দেখুন তো তাহলে 31 জুলাই হয়ে যাবে। দেখুন 31 জুলাই ফাঁকা আছে।
But by that time, the district magistrate will file a report. That your lordship will say. By before the next date of it.
That is
Before
the
30th.
obvious.
আচ্ছা, and district magistrate shall through the representative of the state shall file a report indicating the outcome of such meeting. Outcome of such meeting.
Right.
And with
Okay.
advance copy Lordship, before 30th petitioner, before 30th July.
Before the on the returnable date.
On the return.
And
On the returnable date.
copy may be given in advance to us so that we can
How
make
it
submission.
is-
Acha, advance copy of the same shall be
To all
served.
the parties.
Shall be served to all the parties.
Order is to be
I am
communicated.
entitled to.
All
All the parties will not exclude you. Learned council, all the parties means it will not exclude you. Don't worry.
Grateful.
Obliged.
31st 2 PM.
Grateful.
Obliged.
Reserve your energy for that day.
Yes.
সব ফেরত দিয়ে দিই। বাপরে সব। নিন ডাকুন, পরেরটা ডাকুন, 12, yes. দেখুন আসেনি কেউ, not today.
Led by Mr. Shami Mohammed, Lordship. I'm taking for only 3 days time to file a reply. Can we fix it on Friday, Lordship?
We have already filed an affidavit.
Only affirming is not ready yet.
The High Court has no.
Yet to be affirmed, Lordship.
No, they are the employees of the state government.
Matter has been admitted, opposition reply has been completed, Lordship.
আচ্ছা, আপনি ইয়ে করুন সুমন বাবু। আচ্ছা, আচ্ছা, your name please.
Ambia Khatun.
Acha, Miss Khatun, learned advocate, repenting the petitioner pays for extension of time to file affidavit in reply.
3 days
Stop.
time only, sir.
Mr. Mukherjee did not oppose such pair. In view thereof, time to file affidavit in a reply is extended for a further period of 1 week. Leaves the matter for further consideration 1 week hence.
Lordship, can you fix a date? 15 next week. 15
Every
Tuesday.
matter date can be,
Lordship,
it will appear, don't worry. It
Lordship,
will,
can you fix it 15, Lordship?
15th, the
15th,
15th, you in the
16th,
circumstances. On in this 15th.
15 July, Lordship. Or 16, 17. Can you fix a date?
Mr. Mukherjee has gone. So,
I'll
so 16.
16, grateful, Lordship. 16, Lordship.
16.
16, great.
16, Mr. Mukherjee. 16. Okay. Yes.
14 Malar, I am appearing for the state respondent. Malar, I am filing.
Both sides are not here, matter will be taken up.
No, Malar, kindly take up this matter tomorrow.
কেন? Tomorrow একই জিনিস। Both sides না থাকলে হবে। বাংলা বল।
Day after tomorrow, Malar.
Let me start. Really, yeah. Let me earn my peace.
Oh.
Malar, your lordship kindly record that I am filing a report.
Filing report.
Kindly take up day after tomorrow, Malar.
Acha, report filed on behalf of the state in terms of the order dated
22nd of August 2023.
22nd of August 2023 is taken on record.
And reply also?
Acha, yes, an exception to that report filed on behalf of আচ্ছা তাহলে একসঙ্গে করে দিন না রিপোর্ট ইন ফাইল অ্যান এক্সেপশন কি হচ্ছে আচ্ছা ইয়ে and by quashing, yes. And 19 September 2023, and
Can you hear me for 5 minutes then?
and you want benefits under the notification of 16th October 2020. Another benefit under a notification such and such. Whether it is cancellation of exercise license or
My lord, seeking same benefit, my lord, who are the IT at par with IT personnel. Now the question is, my lord, whether they are qualified or not to get that benefit or not. That is the only issue. The Finance Department, my lord, rejected their claims by saying that they are not qualified. That is, my lord, your lordship will find at page 75, my lord.
So the petitioner are contractually engaged IT personnel.
Yes.
Now they are claiming benefit as per PNR department notification dated 16th October 2020. Where is 16
They are
October?
employees of BEFCO, my lord.
Huh?
They are employees of BEFCO, my lord. This is, my lord, government.
By this way, my lord will not be able to appreciate. I have better pain. In this department.
Oh.
And here before fine.
Yes.
There are foreign liquor manufacturers and warehouses, my lord knows. They are employed there. Privately owned, they are all employees there. Government issued a notification that henceforth the lucrative business, government first they will do itself. Corporation has been formed. Notification that the earlier license which was granted to the private organization will be stopped. So on that night, when it was issued, we are on street.
Yes.
All private manufacturers closed. Government issued a notification that who have this experience, qualification in this line. So we are considered we are in the post of data entry operators. We are working there in the private sector. My submission would be the duty cast on the state when you are closing down all the manufacturers and we are having the knowledge of doing that work, immediately government has no personnel to go on with their corporation activities. So immediately they took us with that notification. And we were posted, giving assignment, we are doing our job. But today, can they say, apart from other points, which my learners are doing,
This is a beneficial obligation on the part of the state government to absorb us. That has been done. And we are working there, having experience only for the purpose of running their business. Immediately they formed it. They utilize our expertise. And apart from the legal complications, now throw away when the organization is running condition and they are getting some employees out there to replace me. Apart from any other thing, kindly consider this. It is not that I have a backdoor appointment.
No.
If I have a backdoor appointment, criteria will
So you absorbed under the corporation from your earlier employer under which terms and condition? On which terms and conditions?
They have issued a notification that those who
are working under the
they say who have experience
yes
on data entry operation.
Yes.
They will be allowed.
Yes.
They are taken as a contractual employment because on that day there was no other employee for the newly born
corporation.
So we are proud and we are allowing to work. Now they can kick me on any other ground except my lord disciplinary proceeding. It is first by submission. That's why I say pain is deeper. Now, even if my lord, which is not, if it is my lord, I am not fulfilling the criteria. Because they have relaxed that. On the date of our entry into service, they have relaxed. Nowadays, otherwise we will be on mistake. All companies was closed down and we were taken by the corporation. Now can we apply with my lord friend said whether I am fulfilling the condition or not. That I am saying I can demonstrate it for my lord that we are. This is a borderline. Now he is saying
আপনার যদি
ইচ্ছা বলুন
ওকে আচ্ছা আমি লিখে দিই নেব
because we were there, we were allowed to take it in there to run their job. When they started it, then my lord should be kicked out.
Okay, you just showed that it is not a moral duty, but they have the legal duty. Moral duty cannot be enforced.
No.
Legal duty but statutory duty can be enforced.
A state my lord can do this. But kindly see those line of judgments where
Model employer will act with
a landlord. Even if he is a landlord under the statute, he has to act in accordance with the statute. He cannot do whatever he likes. Whatever a private landlord can do, a government landlord cannot do that. This line has to be complied with. Apart from that, I am concerned that I am fulfilling all the criteria in term. Now, once can you look to the order of Justice Tika? Justice Banerjee has crystallized that issue. Order dated 28th August 2020.
they have assured that you will be your engagement would be up to your 60 years, up to the that is there, and you will get the benefit of all the relevant circulars.
Asking for that, improvement of that notification. They are saying no, you cannot get it. Now, order.
You want that the benefits of such notification. The para teacher such and such they are getting. Yes.
Absorption, no.
Benefit of that. Yes.
That see, Justice Lopita Banerjee has crystallized the issue. You will also look to that.
Yes. Now I have got it. So why you give that benefit?
My lord, there are some impediments that I shall show that whether they are fulfilling, my lord, those conditions, my lord, contained in that memorandum. The finance, we referred this issue, my lord, to the finance department. The finance department, my lord, having considered everything, my lord, found that they are not qualified. The class 10 pass. Some are, my lord, below graduate. Whether
so what sort of educational qualification is required to avail that benefit? Graduate.
Let them, my lord, show. I shall show, my lord.
You have
all the cases, my lord, everyone's case.
Shown that one of our petitioner before my lord is casting. not a single. Maybe
So only count that they are lacking requisite educational qualification to avail of that benefit.
Second, my lord, the nature of duty. The only that nomenclature, my lord, that data entry operator, they are basically floor manager, my lord. The IT professionals, my lord, or the IT personnel, my lord, who are getting those benefits, my lord, they are, my lord, attached with e-projects of the government. Now, these e-projects of the government is, my lord, the nature and work of the e-projects are completely different
not in that
with
why
those
fraud.
who are engaged in WebCo. Therefore, my lord, this is, my lord, two common differences, my lord. They must show.
Not
My
in
lord,
their mind
shall,
when you are
I
fraud.
shall, my lord, satisfy, lord. Try to satisfy.
Okay. So they have engaged, they have been engaged in project-based work.
Yes.
It is also now. No, their submission.
Dealing with, my lord, leakers, not e-projects. Dealing with leakers. They are basically floor managers. However, my lord, that nomenclature has my lord, also attached, my lord, that floor manager come data entry operator. Now they are asking that benefit that since data entry operator, my lord, has been incorporated with their post, therefore we are entitled to receive this benefit. This is the issue.
Okay, got it. Acha. Had the learned senior advocate, had Mr. Bosu. Acha, duly attested by Mr. Mujumdar, learned Bosu senior.
One document has been incorporated. Can you get that please? I've served it.
I have received.
Oh. Page 14. 15, okay.
After the respondent. My lords, that judgment, Mohammed Sabir, has got appreciation from both bar and bench. I must bring it to your lordship's kind notice. Mohammed Sabir's judgments. My lord.
Well, the appeal has been prepared on.
Appeal not as yet, but I also have been appreciated. I also appreciated the author of the judgments many benches also.
Okay. Thank you. As of what you want.
That should be reported. Kindly text it.
Okay, let's Gamachi. You want your appointment under diet in harness category without any consent. That matter. Family. Who is the private respondent?
I am against, but it is not happening.
No, it's a private disputes, no. Let them resolve the disputes. Kindly consider whether this at this time
dispute between yourself and your brother.
Last order.
You could not resolve.
Not resolve.
Now, how you on that date I stated that now there is a requirement and a prescribed form they have introduced a prescribed
no objection certificate is
no objection certificate, son. So the form is now a part of the statute. So you have to mandatorily fill up the form and comply with the instruction contained in the said form. Now, how a court of law can direct that you ignore non-compliance of this part and
I am not on that. My last order, my lord, should have the copy and the order also. I serve. Last order, my lord, can you see?
So you file affidavit in opposition.
No, we have submitted.
You have annexed the rule.
Lordship, at page.
And whether private respondent presented any application seeking his.
Private respondent made a representation to us.
After the
and we have considered the representations which is under challenge before your lordship in a writ petitions. We have said, very well, you get no objections from your brother. And follow the rules which has been laid down and applicable in this given case. That is, no objection certification is required from the family. But otherwise, we are unable to consider in verbatim as per direction of the Honorable High Court. So, as yet, we have not received any no objection certificate.
From either of the
parties. So, at first, we are to receive the certificate.
So, whether the rule has addressed this issue?
Yes, we have mentioned.
In case, if any disease employee, any employee died, leaving behind him more than one legal years, and if any legal years fail to produce the no objection certificate from the another, then what will be the...
That has not been specifically said so. But only
so rule is silent?
Rule itself is not as a whole. Page 18, the rule. The
page 18. No, 18. You locate what rule has said. That in such circumstances, how the issue will be dealt with.
That's why we have served notice to all both of them. Let them appear before the authority.
So you resolve the issue.
Kindly come to page 15.
You have to run your administration. Court will not run your administration. So the problem which you are facing, you first address the same.
At this juncture, my responsible submission will also be not to interfere in these petitions and not to consider. Let the authority decide. Is it premature? Absolutely premature applications. Unless this private disputes is resolved. So there can't be said that the decisions of the authority is arbitrary in nature.
And now petitioner want that petitioner submit application in prescribed form.
And
Huh?
private respondent also.
No, he has not filed prescribed form. He just made it.
He made a representation in terms of the direction of this honorable court.
Where is that direction? Where is that order, honorable court's order?
Very. Kindly come to repetition. Page 19.
Page 19 of your epidemic opposition.
No, they are writ petitions.
Writ petition.
আচ্ছা আগে এটা দাও তো single bench order.
Your petitioner name is Sanjay Kundu.
I'm referring. To 16 ওখানে কোথায় বলেছে At first, we'll kindly consider London single judge's order. Page 16.
Yes, the organization petitioner by the a petition has been made by the petitioner on 80 July for consideration of his prayer for compassionate appointment. That's right.
Order for the petitioner.
ঠিক আছে সঞ্জয় কুন্ডু এবার আমরা করলাম
Well, this is that order. They prefer an appeal before the division.
We prefer an appeal. Appeal court upheld the order of the London single judge, directed us to consider.
Have you considered?
Yes. Now that we have considered and passed a reason order. Speaking order in that sense.
Where is that?
That is at page 25.
What is your ultimate decision? And whereas
Ultimate decision,
without
last part, page
no objection
27.
from ASO cannot be considered as per policy of the prevalent at the time of date. So the application is hereby disposed of. It is further embedded a single application for employment exchange in needs to be submitted for further proceedings.
আমরা তো একটা করেছি
My lord, in the meantime, to serve the order to the private school. Has accepted his filing application. And earlier, the petition will come here from the order dated 24th of July 2020.
We have received two representations from two brothers.
What the order from the honorable civil. Thereafter, he made an application by my elder brother. The appeal court, they prefer, has not settled anything. After the appeal court order, they first time inform us that one has applied for. That is not the single bench order. Thereafter, he made the application. And now my lord kindly see, as per my lord order, as per the order, he accepted. He is not coming because he has not interested. Earlier, my lord, that is 24th of July 2024, affidavit of service filed in court today is taken on record. Despite service, the respondent of court remains unrepresented. When we took the decision, that is order recorded by so he is not election be given to give my appointment. If he is not coming, he is not getting no objection.
Right
That-
now, Malad, there is no cause of action.
Yes. That was
Cause of action arose.
Division bench order passed. Now, the election to appoint me.
Mr. Haldar, most probably court expressed its mind that non-appearance before the court despite receipt of a notice whether can be construed to a no objection certificate within the meaning of that your rule and such. Admittedly, despite receipt of notice from you on repeated occasion, whereby you have asked him to appear in this matter, it is not a criminal matter. It is not a criminal matter. Even one party says that yes, decide issue the ex parte, I shall accept the decision. So whether non-appearance, again excuse repetition, his non-appearance before this court despite receipt of notice sent through you can be construed to a no objection certificate.
No, that is not.
So-
But he is not interested. For that, he is
How could the read code will interfere?
choosing all the they are accepting but not coming.
He has filed, presented application seeking his employment assistant.
To the authority.
And you also make claim. Now the respondent
There is order on
respondent authority has stated you that any of you prefer a no objection certificate from other.
not giving
If you can file, get it, you file it. If you your brother can get it, your brother will file it. And who will be able to produce the no objection certificate? He will be favored with the compassionate appointment. Now, how the court will enforce that you, without obtaining no objection certificate from the legal heirs, you grant employer compassionate atonement to a particular out of this, accept the petitioner contention.
matter by the honorable court to appear. Receive, he is not appearing. So my lord can
Again, you will.
my lord can pass an order to directing the authority to give him the appointment. Only to
No, it's not. It's not.
My-
But suggestion though. The court relates the concerned police.
How?
এটা করা যায় রিট কোড করতেই পারে কনসার্ন যে লোকাল থানা ওসি কে বলে তাকে পুলিশ করা করতে
That
But-
is so I have not.
through
Huh?
this is my suggestion subject to appeal. If my lords in this circumstances my lord can direct the register appellate side to issue one or communicate one note your lordship's order to the local police station so that the
Why?
police officer can bring him that I think.
Why?
That can be done. Otherwise he has
He
to
is
be
not
present.
coming. He is not. He was.
If he says in open court give his consent, that will be recorded by this court, and accordingly we'll proceed.
What is the motto of giving a compassionate appointment?
Compassionate appointment, my lord, in my understanding,
To save the family,
to
to
get
save the
tide over the
family,
situation
to
on
tide
the
over the situation.
situations.
Aye.
In certain days,
Sense of immediacy is to be there.
lordship.
Okay,
Yeah,
Devabrata the judgment lastly, 2023. Okay, so here the family, two legal heirs are fighting. They have failed to resolve this issue within their family. Now they are seeking intervention of the court. Now whether court can enforce any of them to issue no objection certificate,
So consent.
or whether court can consider such conduct is that he is not appearing in the court despite receipt of notice from the petitioner, so that conduct will be impliedly treated as a no objection.
No, that
Court
that
can.
You are saying no, you are not being able to say yes.
My lord, what I.
Although you are seeking an order.
So can dispose of the writ petition.
He is not appearing. The court has the power to pass such order. Government in order to solve the problem.
I could have very much happy if I could have passed that order in your favor.
Yes, my lord.
But you are, Mr. Haldar, you know very well you are appearing in such a court that order can be treated as a precedent. Henceforth, this order will be so as a precedent that, look, in this situation, this court has passed this order. So here also the petitioner is not coming, despite receipt of repeated notice. So you direct. And all the coordinate bench, either he is to disagree with the view, send the matter to the adjournment, or he used to follow the same.
Absolutely correct.
Actually, what order will pass, that will shall have effect to creating a precedent. Actually, a dispute within a family could not be resolved. Now we are seeking intervention of this court and directing.
I made him party. I served the repetition.
Rather, we court should confine its consideration. Where is the infirmity in the order? Challenging this petition. You have challenged Mr. Haldar, you have challenged the legality of this order. So you show what is the infirmity.
He is not coming. He is
Yes,
not.
now it's admission. Can you record my?
The authority, so Mr. Haldar, authority has not done any wrong asking you and even your brother to produce no objection certificate from another.
Honorable single direction me for consideration. Petition means same order. So he is not any order from this honorable court, not from single bench. After the single bench order, Tika balances order. So he made an consider that. We have come before this court on the order of the Honorable High Court. And division bench also supported me. He has no order, but he is not giving order. That is
Even there is no cause of action arose because there is no rejections by the authority.
There is no rejection.
No rejection.
Actually, they have not rejected. They have asked you to produce no objection from other legal.
The authority can direct that they will call the court to come before them to consider that.
I dispose of the petitions. There is no, there is a divide of interest.
Asun, a dispute within a family regarding grant of no objection fight with your brother. Go take his blessings. Father means he does want a honor from the father. Problem is father thinks who is my elder brother? I am everything in my family. Go take blessing from your brother. I think within a minute the matter will be solved.
Fine.
Yes. Go and touch your feet, his feet, and take blessing. You will get the no objection certificate within 5 minutes.
Absolutely.
I think. Yes. Whether it can be.
Item number 60.
Oh, that matter.
I read by Mr. Doctor. We have filed the affidavit of compliance for 4. Affidavit of compliance for number 5.
So the petitioner is not satisfied that the order has been fully complied with.
Order has been fully complied with. Now, if he is unsatisfied with the quantum, then he has to file a fresh petition because this tries a fresh cause of action. As per the lordship order, we have released everything.
Well, so I am fixing a date for hearing. I am to apply this mind whether order has been complied with or order has not been complied with or not.
Subject to lordship.
What according to you they have not paid or whether any further it will not solve your problem.
Only mathematical calculation is
Court directed them to grant their retirement benefit as and to reckon half of their service rendered as a casual employee. They have done it.
Yes, they have done.
But at the time of granting or making calculation of the amount, they have misguided and they have not taken into account the gratuity.
Gratuity portion and rebate.
So you take the instruction.
The document is annexed with the complaint. You should kindly take the complaint.
Don't at this stage, don't take it as a adversarial litigation anymore. You take instruction whether they will be entitled to get gratuity and they are claiming. So whether or not they are claiming that they will get the gratuity and leave encashment.
They have disbursed the gratuity and leave encashment. One term of the gratuity amount, they have not calculated according to the law. According to the my lord, specifically directed Rule 1972, when the federal calculated on the basis of the rule of 1972. But they have not calculated on the basis of the 1972, and also their circular also. Their circular 2007. Their circular. How the calculation of the base by the and the Gratuity Act also. Well, you can see the Gratuity Act once.
Documents are all of the instruction and not instruction. Yes, these documents my learned friend, my learned senior friend is referring to.
So now the petitioner contention is that court directed you to pay the benefit, retirement benefit as per the 1972 rule.
That we have done.
But you have not done it.
Yes.
You have made less payment of gratuity amount and leave encashment.
The thing is this if this
So that payment according to the petitioner is not a payment and as per the or in accordance with 72 rule. According to the petitioner.
It is the spirit of the judgment, my lord. Your lordship's judgment.
these facts are
So you take instruction.
one thing, Lordship, this
Yes, I have got your point that it is a fresh cause of action and
not
the
on that, Lordship. These facts that we have paid less amount of gratuity And the gratuity amount should have been more according to this circular. That's why these are part of the exception. I'll take fresh instruction. Are these part of the exception?
Yes, yes. Part of the.
No, no, one thing. Now you have no liberty to deviate the order or to go against the order. Okay? And court also cannot modify the order. It is contempt proceedings. Now court directed you to grant benefit, retired benefit, including the pension and such gratuity, as per or in accordance with the 72 rules, 1972 rules.
As per my instruction, we have
Now,
done that.
if the payment is not made as per that rules, whether contempt will attract or not,
I'll take instruction and go through his exception.
and you don't take it as an adversarial litigation at this stage. Some poor casual employee has come before this court. You who are suffering from 1999, from 1999, you consider their plight. You sitting in a chair by stroke of a pen, throw everything away. But
Passed by
you
the Supreme
consider,
Court, I will comply it in toto.
you take this instruction that they are still coming, that the payment of gratuity and leave encashment has not been made as per 1972 rules. Clear?
Clear.
Come on that date.
Although the amount
Are the landed, you submitted what?
Exception is compliance.
Acha, the compliance report filed on behalf of the alleged contemners
number 3
and the exception to that report filed on behalf of the petitioner are taken on record.
Affidavit in compliance in respect of contender number 1, 2, 2A and 4 are already on record. That was filed on the last occasion. Today I am filing the affidavit of compliance on behalf of only contender number 3.
No.
Acha, affidavit in compliance filed on behalf of alleged contender number 3 and the exception thereto filed on behalf of the petitioner are taken on record.
Copy is also served on.
Acha, ठीक है. Acha, copy of such affidavit, how they have filed the exception?
No. On the last occasion, I filed 4 affidavits. This is the 5th one.
So exception to that affidavit.
Yes.
Today you have filed 4 numbers of exception.
One composite exception.
Comprehensive.
Comprehensive exception.
তাহলে এটা কেটে দিন আচ্ছা
One exception.
কেটে দিন আচ্ছা আপনি তাহলে আগে লিখুন আচ্ছা তাহলে আপনি লিখুন a comprehensive exception to the affidavits in compliance filed separately filed by alleged contender number 1, 2, 2A and 4 আচ্ছা কি বলি filed on behalf of the petitioner বলেছি তো না affidavit in compliance exception filed on
নোটিশ একটু লিখে নিন ওই
হ্যাঁ।
ডাব্লিউপি নাম্বারটা স্লিপ দিয়েছে
Whether within that period hearing will be concluded.
but I will complete my part.
You will complete, then Mr. Bandyopadhyay will say.
I tell you lordship it will be done, it will be done. I will come with a I'll come with a
So you have a talk with the Mr. Bandyopadhyay.
I'll
that
come
on
with a
that
conclusion. Yes, we'll
If I can dictate the order in open court, I shall dictate,
I
or
will not
otherwise
take
I
much
shall
time. I
read
will-
up the judgment.
Yes.
So that can be done.
yes.
Huh? Okay? Yes.
17 July 12:30. I'm grateful to lordship.
না না সেটা ডিফিকাল্ট না, আপনি শুধু টাইপোগ্রাফিক্যাল ইয়েগুলো করবেন। উনি তো বললেন যে স্কুলের নাম ভুল হয়েছে আর একটা মাইনে ভুল হয়েছে ওই ইয়ে আছে। না না বেশি যদি বলবেন টাইপোগ্রাফিক্যাল ছাড়া যদি কিছু হয় তাহলে আপনি মডিফিকেশন অ্যাপ্লিকেশন করবেন। এখন বলছেন উনি ভুল করেছেন, কি কি এমনি চাইছেন কি এমনি সাবস্ট্যান্স তো কিছু চাইছে না, স্কুলের নাম হ্যাঁ করে দিন, কারেকশন করে দিন, সেপারেট কারেকশন করে দিন। না 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 তাহলে নয়, আপনি শুধু হ্যাঁ 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 স্কুলের নামটা চেঞ্জ হবে, হ্যাঁ হ্যাঁ অনলি স্কুলের নাম। Yes.
Item number 21.
Yes. হ্যাঁ কালকে একটা জাজমেন্ট ফর জাজমেন্ট থাকবে। Yes. All parties are present.
For the state and the petitioner, I am for the petitioner.
You are appearing for the state. Yes. Yes.
Now let us start from the impugned order that appears at page 68.
Oh, there was condonation of a delay. Matter was dismissed for default.
Yes, ma'am. That was restored. I think.
Order was passed by Miss, subject to payment of cost. Cost to whom? To the opposite party positively. Have you paid the cost? Have you received?
It's my instruction that the I was not there at that juncture, my lord.
Yes.
It's my instruction that has been paid.
Paid. Okay. Yes, you want rejection of an impugned order.
Impugned order at page 68.
So by commissioner in department, we and here communicated to the to execute freehold. Page
68.
68.
68.
68, yes.
It's order dated 24th of June 2015, pursuant to an order passed by this honorable court in the earlier round of litigation that was passed. May I read it for my lord, ma'am?
Yes.
Order in compliance with the direction dated 25th of March 2015, passed by the Honorable Justice Aniruddha Bose, the writ petition was disposed of by the Honorable Justice Aniruddha Bose with a direction on the respondents to take a decision on the question of grant and distribution of title deeds to the members of the petitioner number 1. The petitioners were heard in my chamber. In course of hearing in the matter, the following points emerged: that there is presently no physical existence of any colony on the location in question. Dag number question that's given, but the south of the said location exists the colony known as Dakshin Panchanagar colony, where 240 numbers of DP family are reportedly to have been settled. The location in question refers to Dag number 383, for which the petitioner claimed freehold title deeds on the strength of being displaced families, and it is submitted in the writ petition to this effect that they have now having been living in rented house at different areas nearby the location in question.
ADMRR Alipur South 24 Parganas has initiated to settle them at the colony land belonging to the RR&R department, but subsequently the said initiative was dropped because the land in question was low-lying and get waterlogged over there, making it difficult for the administrative authority to rehabilitate them. So, my lord, this is that initiation was there. Ultimately, they dropped for this reason. Now, that the petitioners are not in possession of the offer letter in respect of the said land as proof of occupation of land on the part of them. This indicates that the petitioner in question were not in possession of the land for which they filed writ petition before the Honorable Court. The land in question comprises of dag number so and so. As on office record, it indicates that the petitioner number 1 prayed for inclusion of strip of land comprising RS record number so and so belong to is vested to the state of West Bengal, measuring 8.64 acres for maintaining provisions of road, playground, open space, etc. In addition to providing eto katas of land to each of the eligible DP families with CS record number so and so, as on office records, it indicates that an inquiry was conducted in terms of Department Order number so and so dated 5th of July 2011 to find out status of 219 enlisted families, and out of which 164 families were identified who are residing outside the adjoining areas of the proposed land Indranagar on rental basis. However, a probable site plan for accommodation of 219 refugee families were made and authenticated. It is a fact that the said land in question, being number so and so, are acquired by the RR department and kept for rehabilitation of DP families as per normal norms for acquisition. But the land is physically low-lying, and in the rainy season, the water forms the watery area, etc. It is also a fact that it was intimated to develop the said land in question by way of earth filling, but subsequently the same was severed after careful review of the situation. As per the report, petitioners of the present writ petition do not squatter on the land. Their petition for confirmation of so and so cannot be considered in favor of them in the light of the above. My lord, so the land was identified, the families were identified.
You are claiming freehold. You are claiming grant of title deed.
Yes.
In respect of plot number. In respect of plot number 339.
339.
Of the said Mauja.
Yes.
The department says that 3 plots, namely 378 part, 379 full and 380 full, were identified to be settled in favor of the DP family. DP means
displaced only. The
displaced,
like the
displaced. So displaced family. So your land is not part of that land.
Prior to that,
yes.
Prior to that, when a state has filed one opposition in this matter, in the opposition there is a point of maintainability. There is a point of maintainability. Kindly sees me, Lord, the state's opposition filed on record on 30th October 2017.
And
it has taken a point of maintainability in its opposition on the issue that what right do they have that they're invoking, my lord, writ jurisdiction and paying for a mandamus. We are residing in the land for 30 years. We are the displaced people from East Pakistan, Bangladesh. You give us land. This is what. And the very first question is that whether a writ is maintainable by a registered society. Because here the committee has come with your lordship. In the paragraph, it says that he is the president of the committee, must be a committee, Miller. The committee is formed under the West Society Station Act. There is a Madras High Court judgment followed by Justice Dipankar Datta's judgment of our Honorable Court that writ by society is not maintainable. By Madras High Court and one by Honorable Justice Dipankar Datta. So here it is by the society. And secondly, this what
It cannot be
infringement of right, what fundamental, what
it
right?
cannot be treated as a person aggrieved.
Yes, my lord. Yes, yes. Society cannot maintain. Individual persons can come and maintain. But here, kindly sees the cause title. Cause title Indira Nagar Colony Committee, represented by General Secretary. And 2 is Tanik Singh.
But in this case, the order which has been challenged in the writ petition was passed in compliance with the order passed in an earlier writ petition. At that time, the issue of maintainability was not raised.
Illegality cannot be
Perpetuated, you will say. I am supplying the word. Okay, perpetuated. But whether omission to raise this point at the earliest possible opportunity will be treated as a waiver on your part or not.
No, in this pilot, in this writ petition, kindly see the opposition of the state pilot. Kindly see the opposition of the state. It was not filed by me, but my predecessor. The opposition was filed.
Yes, whatever you have got the occasion to read it.
I have
not got that occasion. Yes.
Could go.
However, that issue has been raised, whether this point of it is maintainable or not. Fact, it is admitted position that the raised when the earlier writ petition was moved by the same petitioner did not raise this issue. Now, whether this issue can be
And that was not
entertained now.
that was even not raised in at the time of moving the motion. Of the present motion, writ petition, that was not raised. That's coming in the way of affidavit.
Maintainability kept open. Yes, I don't find any reflection from the order dated the first order of 24th September 2019. But from the opposition, I find the state takes the very first ground. At the very outset, I state the present writ petition is not maintainable and is liable to be dismissed at the threshold. This is
if Mr. Galib, I accept your such objection, then I indirectly will say that the earlier bench should not have entertained the earlier writ petition.
But will a point of law
Acceptance of this plea objection would be a declaration that the earlier bench should not have entertained such the earlier writ petition.
Point of law mirror can be raised at any point of time.
And
the point of law.
By taking this technical point,
ignorance of not technical.
Shows that somehow my learned friend's case is not strong.
No, secondly, there are.
Somehow my learned friend's case is not strong. That's why he is taking the shelter of technicality.
No, you don't you raise the point which has been raised by the court as well as Mr. Galib.
My answer would
that even if it is settled law that a registered society cannot prepare a writ petition, he cannot be treated as a person aggrieved. So there is a judgment as Mr. Galib is claiming. Now, admittedly, state did not raise this issue when the earlier writ petition was moved by the same petitioner.
As well as when this writ petition was first moved before.
Yes, at the time of admission of this writ petition also, this point has not been raised. That this point taken belatedly by the state, whether can be entertained at this stage or not.
But point of law.
Point of law. And you consider, Mr. Galib, if this court accepts this, that would be tantamount to a declaration that the earlier coordinate bench has committed a wrong in entertaining this writ petition.
And secondly, my lord, the other point which the question of maintainability is that what legal
right they have got.
Your fundamental right stands infringed.
Now you
300A.
You always come with the Moninder Singh Gill's judgment. Now I shall refer this judgment to you also. This point has not been raised by the authority concerned in the order rejection order. This point which has been raised that they have no right.
No prayer.
Rather, authority concerned says that the area is a
Cannot
watery
be given,
area.
cannot be given.
Area from surrounding locality flows to this area during monsoon season and such, so it is not inhabitable.
Lordship, but here, before the authority, my lord, the prayer was not for Mandamus. It was not Article 226 petition before the authority. Before your lordship challenging the recent order passed by the authority, he is invoking writ jurisdiction, praying for Mandamus. What is the Mandamus praying for? Mandamus, my lord, impugned order of rejection, dated so and so be quashed without any delay.
Rejection certiorari.
And further Mandamus, and further commanding to execute freehold lease title deed in favor of the members of the petition number 1. Kindly see prayer A. Clause A.
Executed freehold lease deed in favor of the petition.
Members of the petition number 1. Mandamus.
What the earlier court says.
Earlier
Anyone of you kindly take the court to that earlier order.
Or kindly come to page 50.
50. Is the cost title.
Your lordship will get it at
Operate
64.
64. Only direction to consider this.
Consider the prayer for my lord.
This issue Mr. Galib has not raised. That the writ petition filed, the authority cannot say. Authority has also not said that they have no right to claim. That point. Not rather, order noted that the state took steps to acquire the land and identified 164 families in favor of which those land will be settled.
Lordship is going through the recent order.
76, say 70.
Kindly sees prior to the kindly sees 69.
69, yes, 69.
The order under challenge. Kindly sees Roman 3. Roman 3 of the recent order.
The petitioner is not in a position of offer letter.
Possession of offer letter in respect of the land as proof of occupation of land on part of them. This indicates the petition in question were not in possession of land for which they filed the petition for petition before the so and so. The land in question comprises CSRS DAG number 378 part, 379 full, 380 full, at measuring 4.40 acres under so and so. As on office records, it indicates the petition number 1 prayed for inclusion of a strip of land comprising 339. So they are praying for a new inclusion, new plot, 339 under Moja so and so, vested to the state of West Bengal, measuring 8.64 acres for maintaining provisions of road, playground, open space, etc. So this land that they are asking for now, DAG number 339, yes, it's an acquired land, but it is for roads, playground, open space, in addition to providing 1.5 to 2 quarters of land to each of the eligible DP families with CSR 378, 379, 380 with a petition dated 5th December 2011. This is with regard to some other colony, which my learned friend is praying for similar footing. As an office record indicate that an inquiry was conducted in terms of so and so to find out the status of 219 enlisted families, and out of which 164 families were identified who are residing outside the adjoining areas of the proposed Indira Nagar colony on rental basis. However, the probable site plan for accommodating 29 if you were made and authenticated, it is a fact that the land in question CS as well, 378 part, 379 full, and 380 full. Huh? Yes, that is appearing in the recent order. So far as 378, 9 and 80 is concerned, they are land physically low-lying, so and so. And my lord, my learned friend has also come up with a supplement.
may I interrupt my learned friend once, my lord, because kindly come to page 49. Page 49. Well, it's going on since 1990. Page, page 49, this is by the Joint Secretary, Refugee Rehabilitation Department, dated 25th of April 2012. That was addressed to the General Secretary of this particular colony, my lord. After discussion with the committee, I inform you that the proposed CSRS DAG numbers 339, which was missing there, 378, 379, and 380, under Moja so as collected record from Land and Land Reforms Office are vested and shally lands are fully belongs to RR department, which lands were acquired in 1955 by the government of West Bengal. Now the department decided to permanently offer the DP families of Indranagar colony, and one site plan issued on 28th of December 2011 for the above DAG numbers was permanently handed over the colony committee. Though illegal objections was raised by some local antisocial outsiders, I also inform you that the above lands are not jurisdiction under the East Kolkata so and so Act, which also. So, my lord, this 339, that's not new inclusion, that was there. But they changed their stand in every occasions.
Okay, they have changed, but you have to prove that you are in possession of any of the land.
Yes. But I should...
the authority has took the plea that no offer letter was issued in your favor, and on inquiry it came to light that it revealed that you are living in a rented house at different areas nearby the location in question. So you are not possessing any of this land
now,
including the plot number 339.
Well, in one hand, they are saying it's a watery land, it's a low land that needs to be developed. In another hand, they are saying I am not on that land. But may I place the documents one by one? Well, it will take some time. Well, I shall prove that we were there and we were asked to leave it for the purpose of development. I will show all documents to your lordship. Kindly come to page 31, the first annexure. This is of 87.
Yes.
This was written by this particular committee to the Commissioner of RR Department. The refugee of Indranagar colony beg to draw your kind attention for consideration of following facts. This colony is situated in adjacent east side of Eastern Metropolitan Bypass Road at the following DAG numbers. At Moja, so-and-so, jail number so-and-so, sheet number so-and-so. That's there. These lands were acquired by the government of West Bengal under notification dated 1543, land development dated 22nd of April 55. Declaration number so-and-so, all that has been given. After discussion with competent authority, it was decided to distribute these lands to the refugee of colony. The members of this colony are very poor and living in thatched house with marginal income of daily wages. They have no way for permanent settlement of their families. Now, the DAG numbers that has been quoted there. You are requested kindly look into the matter and arrange to issue distribute our unconditional dolils for the permanent settlement of the poor refugees, and for act of kindness we shall ever grateful. That was given.
You have mentioned, but 339 is not there.
Some lands were there, my lord. Let it take his...
No, I have seen we are concerned with the 380,
Well, I shall,
378, 379 and 380.
Well, that was of
but
87.
339 is not there.
That was of 87. Now, kindly come to page 32.
33.
32.
32, yes.
Now, this is of 89.
89, yes.
Subject is regularization of Indranagar colony and distribution deeds to the members of the colony. Now, the undersigned inform you that the members of the colony are residing on the DAG numbers as mentioned of the above mentioned letters dated 12th of January 1987. The above letters forwarded to the department higher authorities for their approval. The DAG numbers as mentioned are full owned by the RR department, acquired in the year 1956 by the government of West Bengal for utilize the rehabilitate the DP, that the displaced persons' families. The lands are vested and Shali lands. This department decided to hand over permanently for the members of the colony after obtaining the approval of the higher authority. The low and rich area of the above mentioned lands will be developed by this department as residential of the families. This is for information, and also request you that the local authorities elements always disturbing the families and try to keep peace on the colony area. So this is from the office of the subdivisional officer. Now I'll kindly come to the next page, that is of 90. This is also by the subdivisional officer. Secretary of the colony, my lord, the DP families of the page 33, my lord. The DP families of Indranagar colonies so and so occupies piece of land measuring eto acre comprising CS DAG number 382, 383, but this land doesn't appear to be acquired by the RR department. However, the authority in the RR department has been requested to convey instruction as to whether the families of the said colony may be rehabilitated on vested land as may be available. On obtaining order, necessary action will be taken in due course. Now, prayers was made by these authorities. Now, I'll kindly come to page 36. Deeds for the members of Indranagar colony situated.
So in 1990, certain deeds were handed over to the families.
Some of the families.
Some of the families who are residing on the plot number mentioned in in that letter, even at page number 36. But in those letters, plot number 339 was not there.
Not there. Now, there is a proposal to shift there to somewhere else. Since 338, 383, that was not also within the acquired area, as it appears from page 33. 382 and 383, those were not acquired. Kindly have a look, page 33.
Yes, not acquired. Yes,
so there is a proposal to shift them somewhere else, accommodate them somewhere else, with the prior approval of the authority, the last paragraph of page 33. Now, I will kindly come to page 37. A notice for the member of Indranagar colony that was issued by the Deputy Director, Rehabilitation. It is being ordered that the persons whose names have been entered in the colony register as member of the colony could not be allowed to stay in the colony, and whose names are not registered as member of the colony should be expelled out of the colony. Now, page 38. This is of 1995.
Yes.
Now, this was by the Refugee Rehabilitation Department to the officer of the special duty. But it indicates regularization of certain colonies. Now, a list was appended there, starts from page 40. And the name of this colony, it appears at page 41, against serial number 37, Indranagar.
Yes.
Now, kindly come to page 42.
Yes.
42, this was by the my lord office of the district magistrate as a colony, as the colony is recognized under 993 serial number 37. The directorate office is already given for permanent settlement for rehabilitation on the member of the members of your colony on the above piece of lands. Though the land records as shally but low and watery, the water will be removed and allotment letters given to the members. So this was the situation 378, 379 and 380. Now kindly come to the next page, page 43. This is of 2009. Now it was also issued by the Joint Secretary. In enclosing a copy of the letter dated so and so from the OSD ex officio Special Secretary Government along with a copy of the enclosure containing representation from the Indiranagar Colony Committee, which speaks for itself, the undersigned is directed to request him to cause an inquiry into the matter and send a report. Now kindly come to page 44. This is a different colony. That's my lord Purbo Panchanogram Dakshin colony. The undersigned is directed to state that the government have been considering for some time past this matter of regularization of the Purbo Panchanogram Dakshin colony under so-and-so, which is not included in any list. We were in the list, my lord, and they were not in the list. Group of recognized, approved by this government. After careful consideration of the different aspects, conditions set forth by the department in respect of aforesaid colony, the governor have been pleased to declare that the aforementioned colony located in the district of South will be treated as special group colony. Now, page 45. This is by the principal secretary, written to the Indiranagar colony. Regularization and also issued deed for the members of Indiranagar colony, Tiljola. Now, DAG numbers are 378, 379, 380. These lands are fully belong to the RR department and permanently decided to hand over the Indiranagar colony. In the meeting with you in my chamber, you requested me again and again for the legal documents, that is distribution of deeds in the name of the members on the above proposed lands, so that no troubles and disturbance arises from the local authorities. I agree with your prayer and try to develop the entire above land by the dependent and arrange to distribute the deeds to the members of your colony. Now, kindly come to page 46. This is written by the Additional District Magistrate, South 24 Parganas. With reference to the above, the following reports are desired by him is sent for taking necessary action. Names of inhabitants of Purbo Panchanogram, the special group which has been declared subsequently, are not in the list of so-and-so DP families of Indiranagar colony as per office record. Presently, the Indiranagar colony committee has submitted the names of 120 plus 82, that's been 202 families. Amongst them, 124 families were in the list of 180 numbers of DP family. 240 of the families are to be rehabilitated at Purbo Panchanogram colony. 49 numbers of the deeds have already been registered. Previously, this colony was existed on DAG number 307, 310, 322, 324, 342, 351, 350, 354, 383, 448, 460, as reported by the colony people. Later on, these families of Indiranagar colony were forced to leave the physical living from the said land. At present, 4 numbers of family are living at DAG number 383 and rest of 198 families are living on rented house, most of which are adjacent to the said DAG number. Name of the families residing over RS DAG number 310 Mojo so-and-so claim to be a member of any colony. Therefore, no plot enumeration was conducted in respect of family regarding over DAG number 310. Now, this is page 47. The undersigned is directed to refer this memo 18th of October 2010 on the above subject and to request him to get development work of the land in question done with the help and assistance of the committee of Sri Devashish Kumar and the working presidents of the colony committee. Write his letter dated so-and-so, necessary layout maps, so much for development that was taken care of. Now, kindly come to the next page, page 48. This is of December 2011. The General Secretary to the Indiranagar colony, that was written. With reference to the above, undersigned is to inform him that the date of demarcation has been fixed in respect of DAG numbers 378 part, 379 and 380 under Moja so-and-so.
Okay, Mr. Jahan, I have read all the annexures.
Then the next is
so admittedly, your name recorded in the register of the society.
Not registered of the society. This society was registered by the government under the, my lord, approved colonies of DP families.
Committee was instructed to maintain a register.
Yes, yes, we have
containing the name and particulars of the
members.
person who started living on those plots of land. Okay.
Yes.
I say at that time 339 was not there.
Not there.
339. Now, but admittedly, that benefit will be available as per the letter to those persons whose name was incorporated in the register maintained by the
colony.
Office of the colony. Admittedly. Now you have to prove and show that your name incorporated in the register.
But I am the colony. I am the colonies before lordship.
Hey, colony, there is a risk.
Yes, we have.
Government has done that.
We have to place that list before lordship.
Every day your president will be changed and two more person will be bring and name will be entered.
No, that occasion never came.
Name will be entered.
But that occasion never came. They never asked for that.
And only 339, the land 339 you will get from a letter of the Joint Secretary, page 49.
Yes.
Except this, you will not find any reference of this plot number from any document. You saw that this plot number, except this, after discussion with the committee, I informed that proposed such and such as collected record. So I am sending them. If they find that their name was incorporated in the register maintained by the colony, or they were residing in those plot of lands, or subsequently decision was taken by the government to incorporate plot number 339, and the petitioner claim is fit to be accepted, then they will accept what can be done.
বলা শেষ করলাম কোথায় বলো তুমি বলো হাসছো যখন
And if the land after development becomes inhabitable, then your prayer will be considered. So many years. Huh?
Better to become a refugee to get property in Kolkata. You can't laugh like this. This is a humanitarian question.
Humanitarian crisis.
Definitely, a person, a group of persons, they have been suffering since 85. They are not the illegal inhabitant of here. No, তুমি এবার হাসতে পারো না দাদা ব্যাপারটা নিয়ে। I'm sorry. Now, we applied for inclusion of 339. So our claim is not restricted to 339 only. And the impression is being given that we are confined only with this 339. It's not that. As an office record indicates that petitioner number 1 prayed for inclusion. That was our prayer for inclusion of particular plot. That's not the only where we reside. But we have given numbers of plot. Let a full-fledged inquiry be conducted and let the report be placed before lordship. Because sometimes they admitted that we were there. Now when this development work that was taken care of, we had to leave that place. We are residing nearby around that particular place. The water logging, everything is there. So they expect you to be there. And it's about 219 families. They are not asking for any business. They are asking for their shelter. And it's the policy of the government to provide. In respect of some colonies, that has already been given. But somehow these people, they didn't get it. And the persons who has no land in West Bengal and they are the smaller DB families, they are entitled to be considered for this. Sometimes they took the proposal, yes, this is to be given. Sketch map was prepared, then somehow dropped. For the benefit of whom, I don't know. They are also human. So laughing at that, that's not proper, at least being an advocate.
Yes, Mr. Galib has done. So what can be done? How
but in work, if your lordship,
how the court can assist you, Mr. Jahan?
my lord, this particular order impugned, it speaks, my lord,
There is
self-contradictory.
two confusion. Whether the president has come, most probably, president or secretary,
The colony itself, my lord.
repented by general secretary, and
Yes.
one Tanik Singh claiming himself to be the working secretary of that colony. 2 person is come. Now it is not clear how many person actually are started residing on those plots and how many plots have been settled in favor of which person. And you are claiming that since the government decided to develop 3 plots, you was forced to live in another place, in a rented house. So that plot should be developed and
We settle it.
along with the same, another new plot 339 should be included, so that on that plot settlement
Person
can
can
be
be
given. Settlement can be given in your favor. It is your contention. Now it is not clear whether your name was actually incorporated, excuse repetition, in the register, because of the fact
Not my name,
the
but name of my
state
member.
says that benefit of such settlement would be given to those persons whose name would be incorporated in the
In my register.
Where is that register?
May I pray for one thing, for lordship?
So what order at this stage you want?
Yes, may I pray for one? Let there be a full-fledged inquiry in presence of the state level authority as well as district level authority. Let them check up the register, let them find out its genuinity and file a report with your lordship. I'm not fighting for this colony itself. I'm concerned about the persons who are really dispossessed.
Yes, Mr. Galib.
My lord, firstly, my lord, my first respectful submission is this petition should be dismissed in limine. That is, my lord, my first contention is that society cannot maintain a writ petition. Secondly, the individual members, since they are claiming to be the displaced persons from East Bangladesh, came to Pakistan, came to India. So individual members, they will have to come and say that, yes, we are displaced persons. We are in possession of the respective place. We have been deprived of the policy decision of the government, which have been given to the refugees. Then only, my lord, there is semblance of any legal right and its infringement thereof may be at least adjudicated. The colony, the secretary, today is telling that 219 families were there. Again, he will come with 313 family. With this, we will go on doing politics. This cannot go on. So this writ petition has to go at the instance of the secretary society. Since he is coming with the plea of 219 or 218 families, giving the shape of Order 1, Rule 8 petition, it is not a public interest litigation. Praying for a Mandamus, can't. My lord, may I place this judgment, lordship? Second, it's a mere three judgment of the Honorable Supreme Court, my lord, 77-1. My lord, may I, my lord, respectfully invite your lordship, my lord?
Yes.
To my lord. 1977 1 SCC 86. Para 9, my lord.
Yes.
The High Court rightly dismissed the petition. It is elementary, though it is to be restated, that no one can ask for a mandamus without a legal right. there must be a judicially enforceable right as well as a legally protected right before one suffering a legal grievance can ask for a mandamus. A person can be said to be aggrieved only when a person is denied a legal right.
Yes.
By someone who has a legal duty to do something or to abstain from doing something. So, my lord, his legal right, even he cannot, my lord, invoke Article 300A of the Constitution of India. Because his land, he does not show that he is an occupier or he is a possessor. I'm not asking for any document. Because, my lord, what my learned friend all along has been referring to, where the memo, yes, we do not deny the memos, the communications, the correspondences by and between the committee and the government. But all those were 88, 89, 2012, 2015 document. But finally, what does the reason order say? Finally, the reason order say is the petitioners are not in possession of the offer letter in question in respect of the said land as proof of occupation of land on the part of them. So, my lord, when the authority, my lord, was passing the reasoned order under challenge before lordship in the year 2015 June, they say that there is no existence of that particular settlement. So now they're trying to make out a case of 218 families and take a plot in the city of Calcutta in the name of refugee rehabilitation on humanitarian crisis. This is a frivolous ground to invoke Article 220 of the Constitution of India.
Okay.
Milord, my next, Milord's respectful plea for your lordship, Milord, may I respectfully invite your lordship, Milord, to the opposition used by the state government, lordship.
Yes.
Milord, may I respectfully invite your lordship, Milord, to para 13, Milord.
Yes.
Milord, para 13, Milord. Milord, kindly sees, Milord, it is the rebuttal, Milord, of Milord paragraph 15 to 19 of the writ petition.
Yes.
So, Milord, kindly sees what are the averments, Milord, in 15 to 19, Milord, of the writ petitions. 15 to 19, Milord, if your lordship, Milord, if I may respectfully invite your lordship, Milord, these are all the memoranda which my learned friend was referring to, your lordship. In rebuttal thereto, Milord, again, Milord, the state government on oath, it says, kindly seize page 8 of the opposition. It is submitted that there is no physical existence of any colony on the location in question. In the year 2017, it says. So 2015, the reasoned order, the authority says that there is no existence of the settlement. 2017, when the affirmation is coming of the affidavit, Milord, it says, Milord, this is, who is the gentleman affirming the affidavit? Working for again as a commissioner in Department of Land and Refugee Rehabilitation, the very concerned department. They are saying, Milord, he is saying that there is no existence, Milord, of this particular colony. When was the affirmation made? Kindly seize the jurat, Milord. Affirmation of this affidavit, 30th October 2017. He says there is no existence. Next, Milord, he is claiming, Milord, that we should be given the same footing with another colony, Purbo Panchannagram colony. Kindly seize our answer to it is paragraph 12. Para 12 of the opposition, we have said, para 12, that they are not on same footing. Now, my learned friend, Milord, has referred to, Milord, first at page 34 of the writ petition, Milord. What does 34 say? 31. What does 31 say, Milord? 31 is the memo of, Milord, 1987. It says that, kindly see the second paragraph, third paragraph. These lands were acquired by the government under notification number so and so, land development dated so and so, declaration number dated so and so.
This is our prayer.
And possessed by so and so.
Our prayer. It's not a notification.
Yes, it is your
Our prayer.
It is your, no, you have quoted a notification over here.
Yes.
Yes. So what do they say? They are saying, this precedent, that these are the dags which were acquired by you for rehabilitation of different colonies, not pinpointing to any particular. Now, my learned friend has referred to your lordship, my lord, page 38.
Yes.
What does page 38 say, my lord? Their colonies, this 38 is the memo of, my lord, 1995 memo. Even in the year 1995, the government is telling, kindly seize, my lord, if I may respectfully invite your lordship, my lord, to the second paragraph. Now, the first, clause 1, it is written. Para 1, kindly seize, my lord. The unrecognized colonies included in the list enclosed at Annexure A, submitted by the refugee organizations, will be surveyed and proposals of the transfer of land. So, what is Annexure A? Annexure A, where their name figures. Their name figures. This Indira colony at page 41, serial number 37. So, in 1985 also they were unrecognized. Even in the year 1995, they were unrecognized. So, after all these correspondences by and between the government and the colony, in the year, at the cost of repetition, I say, in the year 2015, the authority says there is no existence of this particular colony over the plots in question. Secondly, in the affidavit affirmed in 2017, they say the same thing, not in existence. Now, my lord, what is being done? Yes, there is a policy of the government that homestead land can be given to the refugees. There is a policy of the government. My learned friend, I'm very drawing to a close. My learned friend has used one that supplementary affidavit. এটা প্লেস করেছে ফাইল করেছিলে সাপ্লিমেন্টারি এফিডেভিট আমি জানি না জমা The petitioner has used one supplementary affidavit. By he has simply, it's nothing, he has annexed all the memoranda of the government relating to giving of land to the refugees. Very good. We don't deny all those memoranda. But what does the government say in reply to that affidavit? May I show this, my lord? What does the government say in reply to that affidavit? I'm getting it just now. Just government is saying, kindly seize, my lord. My learned friend has used one. Lordship is seeing something else.
Yes.
My learned friend, he has found one supplementary affidavit. That is, it is on court record, affirmed on March 2025. It is nothing but he has annexed, my lord, all the relevant memoranda regarding allotment of land to the refugees.
Yes.
So, all the relevant memoranda with regard to the refugee and rehabilitation department have been annexed. We don't deny. But what we say, may I respectfully invite your lordship to our instruction. Kindly seize me, kindly text of the instruction, 14th May 2025. In reply to this supply affidavit, government has given me an instruction. In reply to the supplementary affidavit, kindly seize me the nomenclature, para-wise statement of fact in respect of supplementary affidavit. Dated, kindly say at the bottom, my lord, 14th May 2025. What does it say? Paragraph 4 is the relevant paragraph only. It says that the district R&R department has taken initiative to regularize the eligible displaced families of the said Indira Nagar squatters colony enlisted under 1998 group. But at the time of taking initiative, it is found by this office the said displaced families are not in effective possession in any land belonging to RR and R department as squatters in this locality under PS Tiljala. However, considering the persuasions of the so-called colony committee of the said Indira Nagar squatters colony, the CS Dang number 378 part 379 and 380 of Mouza Nonadanga, jail number 10 PS Tiljala, which belongs to RR and R department, was brought under consideration for rehabilitation of the eligible displaced families of this colony. The said proposal was forwarded to the R&R Department of West Bengal for necessary approval, but subsequently it is known that the proposed plots of land recorded as necessary approval. Proposed plot of lands recorded as Shali, although physically lowland and filled with water. The development of these plots of land to be required for the rehabilitation of said families. Initially, the Joint Secretary belongs to R&R Department directed this office to get the development work of the land in question by petitioner, owns effort and cost, video order dated so and so of 2011, but the necessary permission for the development of the said plots of land physically filled with water has been withdrawn by the authority concerned. Considering the mass petition of Sri Monindranath Dotto and 830 others, together with the order of Honorable MOS, Minister in charge, there are for stopping the earth filling on CS Dag number 378, 7980 or Moza Swanso, proposed for rehabilitation district family said, until further order, that is letter is annexed at page annexure 1. Kindly see. Kindly see annexure 1.
My lord, would you lordship, can you release the other matters?
No, whether 3:30 today?
No.
No, so
Matters are, there are two fixed matters are there.
So for this court, you will get the all matter released.
Water logging is every year, my lord, we have to think
No,
about
no,
how
no.
it can go.
It is your personal problem. You,
The Lordship kindly sees annexure 1. This is a memo, my lord, by the government of West Bengal from the Joint Secretary to the ADMA. Lordship got it. It's not paginated, and I'm very sorry, my lord. They are writing that it is stopped. So it is adjourned Shali. So, my lord, on one hand, design order says no more in existence. Affidavit says no more in existence. This letter says that there is a direction from the government that you don't fill it up until further order. It's a Shali land. Shali land, because for our department.
Got it.
So, this is the position, Lordship.
Okay, if this 3 plot is developed and it is make it inhabitable, and if they find that your claim to be settled on that land is feasible, then they will act accordingly.
In 2011 onwards, they said, let it be developed. We left the land, the position. Now, certain problem arises and they stop the issue. My lord, if your lordship permits us, we can generate fund.
We can
generate fund to develop this land. By
So initially they granted permission that you fill up this of your own. You
Yes.
fill up this of your own. You will be at the cost. Thereafter, most probably, complaint came from certain sector
the land is
that wetland
Yes.
wetland is being developed by that cannot be permitted. However, government denied that it is not the part of the Kolkata wetland. Wetland, it is called wetland.
Yes.
It is not part. The land belongs to the Calcutta Corporation.
the refugee rehabilitation department.
Refugee Rehabilitation Department. So that part is over. But at that time, the permission which was granted to you earlier, previously to fill up the land, has been withdrawn.
That was not, yes.
Has been withdrawn. Now your contention is that unless those 3 plots are filled up, then you will not be able to.
These plots of land are physically used at present by some group of persons for their commercial gain. Commercial gain. And that's the reason all these troubles are coming since 2011 and today we are in 2025. The persons who are in need of this, who are in need of shelter, but it's nobody's case that there is no colony. This says we are not in physical position of that particular land. We are at the vicinity.
Okay, take down. Sure. 22 ইয়ে ওনার আছে আজকে? ও হ্যাঁ, start.
No, the main respondent is not there. State will answer. I am for the union.
Union of India.
I will only answer on a short point about constitutionality of 73(5). Because notice has been issued by the state.
Today, due to incessant rain, the life was paralyzed in the morning today to some extent.
I have been informed that he is in court number 238. I have informed him that the matter has been taken up.
My lord, may I just submit two lines? My argument is concluded as per the last order. Union is present. The two issue at least he has to address. One, I have challenged the validity of the notification entry 13. He has to address that is notification issued by the union only.
You have filed written of argument, written notes of argument.
Yes, yes.
ইয়ে বাবু কোথায় গেল? এটা বন্ধ করুন তো। In this matter, কন্টিনিউইং ম্যাটার করে শেষ করবো। হ্যাঁ। ও ও দ্যাট
Number 17.
Lord, I appear for the petition. Lord, your lordship has heard this matter. It's a part-heard matter. I'll just remind your lordship, Lord, what is the matter about.
May I make a submission?
Yes.
Lord, very recently, my lord, I have been briefed to appear on behalf of the authority.
Oh, that matter.
But I have been briefed to appear.
Lord, on the last occasion, my learned friend was not there.
I have been briefed
Lord,
very
the
recently to
arguing
appear.
counsel came and said the same thing.
Well, I do not know what was said, but
He came and said the same thing that I have been newly briefed. So I will
Yes,
take
said
time.
that you have been newly briefed.
Maybe I can.
No, the prejudicial difficulty is this. I tell your lordship,
I am
this is my prejudice.
trying to recollect after retirement.
Yes, no. This is a disciplinary proceedings, exonerated. Then at the time of promotion, they want to reopen it.
Reopen it.
They want to
Stating
review
that the person who passed the order has no authority.
That was their argument.
He of his own assumed that authority and
their-
passed the order.
That is their argument.
But deeply obliged to your lordship, I have not even gone through that much.
No.
As a
I am trying to recollect.
I'll take note of that.
I am trying to
argument, your
What I have done is that I have stuck on many stick-ons so that it seems I've read it.
Oh,
Tell my lord, if my learned friend is in difficulty, I am not opposing. Of course, he needs time to get ready. There is one difficulty. My lord, on the last occasion I had submitted, my client has been placed, he's an assistant manager. He has been placed in a godown. And he sits there. He has been given a table in Tangra. There is a godown of the corporation.
No idea.
He is sitting there. There's nobody else.
No idea. But all I know is that on the
He is the one who goes, opens the godown, sits there all day. He takes storybooks to read and comes back. He's being victimized in this way.
But I tell you, lordship, I have no idea about this.
But I had made the submission.
I have no
My learned friend does not know. His junior knows.
But I can submit
You are
this.
there.
I will need at the most, I'll seek a adjournment for a week. Not more than that. I don't want, well, I believe there's a stay order already of these proceedings. Passed by this. I don't want this to be prolonged. Well, taken to
Proceeding state. No doubt about
I do not want this to be elongated also.
My promotion is hanging for
No,
3
that's
years.
correct. That's correct. So it's hanging for 3 years. My learned friend will wait for 1 more week. All I'm seeking is that lordship will fix it. But kindly gives me time to come by prepared and loose.
So
Only one request I will make, my lord. Kindly, on the last occasion, your lord, it fell from your lordship, but it has not gone in the order. Let them file a report where my client is posted at the moment.
Let me argue.
No, but I am in service. I may not have been promoted, but I am in service. My lord, an assistant manager cannot be made to sit in a godown year after year with one table and nobody else.
My lord, I am handicapped, but I
No, whether the post in which you have transferred him, whether suitable to his position.
My lord, may I make this submission without understanding the facts? My lord, possibly the submission being made right now, possibly is not the subject matter of the writ
No, it's not.
If it is not the subject matter of the writ petition, I can have the benefit of arguing, and then your lordship will ask. I'll get that instruction, but let me not file that report. I'll take that instruction.
It's not. But
I got the occasion of this petition on many count, it petition and matter on this count that he was kept alone in a office. And
Not a
subsequently,
go down.
subsequently the person become a patient. And doctor asked them, you posted this person along with so that he can enjoy the association of his colleague. Otherwise, he will be totally mentally patient.
Kindly do not direct me to file a report.
If anyone is forced to stay for 7 years or 8 years alone in a place, really it will be
very difficult.
Very difficult.
Very difficult.
Very difficult.
No doubt.
If he cannot get any opportunity to open his mouth to have a talk with some person, it is very difficult. Okay, heard the learned advocate appearing for the respective parties, release the matter for further consideration. When
In case I'm stuck, my lord,
আচ্ছা আর একটা 18 জুলাই ছাড়া আর একটা ফাঁকা
17th, my lord, can you make it 17th?
17th,
17th
17th করুন, 17th করুন।
হ্যাঁ ওকে ওকে স্যার
But if possible, I'll not bargain. Can it be 21st fixed?
21st এ 21শে জুলাই
ও 21শে জুলাই। Sorry, by
17th রাখা, client 17 রাখা।
আরে 16
না 22
by 22nd.
22 so do it on 22
Date time fix করে নিতে পারো, আমার কোনো problem নেই।
22 22
My lord, a time can be fixed, my lord.
time what time can be
11, 12, 12:30, any time, my lord.
Or 120.
My lord, I have made my submissions. I will only remind your lordship, my lord, 10, 15 minutes.
But I-
My lord, friend will argue.
My lord,
you have not
Time
read
is
the
very
brief
simple.
as yet huh?
my lord,
What
if my
time
learned
will
friend
take?
says 10-15 minutes, that means I have to argue a lot, there will be nothing. I have followed it. But I can suggest one, not to your lordship, একটা 25, time fixed. But whatever falls from your lordship. Whatever falls.
12:30
Very well.
12:30 come on that date conclude both of you conclude
12:30.
It will not take more than 10
Okay,
minutes. I will only
দেখো,
show the pages.
okay
শেষ করে দেবো তো তাড়াতাড়ি। কারণ আমার টাইম পাবো।
Great.
okay yes হ্যাঁ 12:30
12টায় করি।
হুম
12টায় করি। আচ্ছা ঠিক আছে।
হ্যাঁ 12:30 পাঠান লিখতে হবে না পাঠান অলরেডি আছে হ্যাঁ নেক্সট
My lord, in item number 18, I am for the respondent bank, my lord. My lord, I would pray for a week's time accommodation only in this matter. Why, my lord? I'm not taking advantage of this today's resolution, but I am in a disadvantageous position because my client is contemplating to engage one senior counsel. So that process is going on, my lord. Within a week, my lord, a week's time only. I'm making a very unusual submission, but that is the reality, my lord. In the morning, I also conveyed this to my learned friend also. That this is my predicament.
Conveying to my learned friend, I have the highest.
No, he told me that he has got some urgency. He told me that he has got some urgency.
The issue is here, may not the petitioner will not. He wants his case to be presented in whatever way. I leave it to your lordship. Me not 1 week. Me not they had the order was made by the vacation bench. Me not long time back. Kindly seize your lordship's order. Here, me not State Bank has defrauded a person.
oh I passed the order
My affidavit of in opposition, my lord.
This order was made long time back. And if they were contemplating to engage someone above,
oh that matter your claim is that bank is failed to point out the some defect material irregularity in the property.
only thing is, me not what I was respectfully submitting, me not,
What is this?
Affidavit in opposition, my lord.
and this is my reply.
আচ্ছা affidavit in opposition filed on behalf of the respondent number
Respondent bank, my lord, we are
on a respondent number 1 to 4 and reply thereto filed on behalf of the petitioner are taken on record. Stop. Further learned advocate appearing for the respective parties list the matter.
my lord, in terms of Money Square's judgment, my lord, a property, even in Tika, having pakka construction, whether it ceases to be Tika or whether it still remains Tika is also one issue, which would also.
That would be decided by the Tika controller.
Yes.
Nimai Kumar's judgment.
That would be detailed.
Nimai Kumar.
That he knows, he's whoever, my lord, that searching officer, he does not know it. He knows it. Let us come back.
You are finding out the reference of the judgment.
I have it.
No, I have it. I have it.
Oh.
He is a tech savvy person, my lord. He has all in his iPad.
Okay, Ashfi. Yes.
কবে রাখলেন হচ্ছে?
25 তারিখ।
কবে রাখলে? 25th. আজ আর হবে? হ্যাঁ? ডেকে দিন না। ওই অর্ডার দিয়ে দিলাম তো, হ্যাঁ। হবে আর? এগুলো সব হিয়ারিং ম্যাটার তো?
হ্যাঁ, এবারে হিয়ারিং।
হ্যাঁ, Oh, go. Yes. আর কি আছে? এইটা ছিল এখন, আর বাকিগুলো নেই এদের। Yes.